asking for a for listing of a matter, my lord. The NIT matter, my lord, it was last listed on 11/9/25. It was supposed to be after 2 weeks. In the Friday, my lord.
But the petitioner responded.
But my lord, these parties to one NIT issue, my lord, because of this case, my lord, we are unable to go ahead with the construction. These are the construction for the school children, my lord. SP children, my lord. My lord, Friday, my lord.
Friday.
No, please, sir. That's what I take to mention, lifting medal. It is related to NIT. Lordship. It was last listed on 3/12/2025, Lordship. And
Okay, next Monday.
Hey, please, Your Lordship. So, Lordship, the item is serial number 7. I'm respondent number 7. I had filed an affidavit yesterday, Your Lordship. I will be allowed to bring that one down.
Yeah, Your Lordship. But I think to mention item number 22 and 23, my lord. These two matters, my lord, already hard by our justice in the liar, my lord. There is an order, my lord, to these people who sound here is my lord. The argument of both the sides has already been submitted.
What is the matter about?
Like that, my lord, suspension of papers to as well as my lord,
Huh?
propriety of search and seizure, my lord. There is the propriety of search and seizure.
Oh,
Of my lord, care price too.
so? Tell me the name. Okay, then. It has been submitted at the bar by the learned counsel appearing on behalf of the petitioner as well as the respondent. That the petition has been heard by the coordinate bench of the so and only the judgment has not yet been announced. Taking into account the above, is this matter before the appropriate.
May I please, Your Lordship? Lordship, I'm praying for listing of a matter for withdrawal. I'm praying for this listing of a matter for withdrawal.
I think. Yes, what is it?
Yes, considering the minor, so then considering this, the mistakes on minor, and subject to this minor court will be and minor.
We asked for 8 weeks.
Yes, ma'am. 2 months, I gave 8 weeks.
We have it on 27th of July, 28th of July.
At least we can submit something, ma'am. 27th.
If we don't progress, then obviously we.
Yes, ma'am.
Miss 8 I.M. delivery, planning, then CTP submits that she has received an instruction dated 8/6/2026 from the AC bracket law, GC Gauhati, requesting for 8 weeks in as much as the administrative approval of the DG is awaited. Isn't it?
Has been waited, and we have to send also MHA, my lord, taken up the formal approval.
The same has to be moved to the competent authority, that is MHA, for formal approval. In that regard, the communication so submitted is kept on record and marked the letter to that. There was Z2, Z3, Z4. Accordingly, this matter on 28th of July 2026. It is made clear that if no substantial progress has been made from this court on the next, if no substantial progress is being shown before this court on the next day, as regards the acquisitioning of the land of the petitioner, or as regards the acquisition of the land of the petitioner, this court shall proceed with the disposal of the petition.
Must bless.
Top of the list.
Must bless.
As per your lordship's order, we had filed on affidavit, lordship, in this case.
Lordship, we have not received the hard copy, Lordship. Lordship, we have not received the hard copy of the affidavit, Lordship. Yesterday night, they have sent them some.
You've got a soft copy.
Lordship,
You've got a soft copy of the affidavit.
Lordship, they have sent through WhatsApp from my senior.
Lordship, there's some maybe mistakes on the part of the advocate clerk. I am taking liability of that, lordships. But I'm being informed that that copy was been served. But whatever maybe, lordships, if they want to take a time, lordship, I had no objection. Otherwise, lordship, we had undisputably said that he is entitled for all the policy benefits in the affidavit.
You said on the last time,
Yes, yes.
submitted that the amount to which the petitioner is entitled on the basis of the policy is less than what has been stated in the petition. And the same has to be worked out after taking into account the installments already paid, the terms and conditions and the bonus payable. The Learning Standing Council, however, submitted that as it would appear from the inquiry made with Kannada Central Bank, an amount of rupees was disbursed to the petitioner. And as such, the LIC is willing to make payment after deducting.
Yes, lordship. After your lordship's order, lordship, we had filed one affidavit, lordship. It is on page 113 probably, if lordship there. Lordship, as per we have calculated the benefit, and lordship, whether that due amount is of around 37 lakhs as of today. As of today, 37 lakhs 5,000, and as per terms and conditions, he entitled for 2 lakhs 75 in each year, lordships. Till 100 years or till the date of the policy. As per the policy term, if you should take the affidavit, page 115, the policy benefits. So the 13 lakhs, lordship, we had there is no dispute. We recovered that amount. Lordship, page 115, lordship, of the affidavit, new affidavit we had filed.
Benefits payable 23 lakhs being accumulated reversely bonus around so 5.5% of the sum. Policy benefit for 23 lakhs. 1, 2, 3, 4, 5. Total 37 lakhs.
Yes.
And then he every year he will get 2,75,000.
Yes. Till 100 years or till date of the applicant.
Where is that statement?
Lordship, however, the first survival benefit will be payable on survival.
5.5, page serial number 2.
Yes, serial number 2, last portion. Lordship. However, the first survival benefit will
So
be
you will
paid.
not add on survival benefit you on so and so, so it's so therefore you are not deducting this 13 lakh.
Yes.
Lordship, it will be taken up in the next week, Lordship. My senior's mother is not well, she's.
How does your senior's mother has to do with this?
She is next week's coaching.
A very sorry state of affairs. Matter could be have been closed. Can be closed. You're entitled to this. They are not deducting the 13 lakhs. What else do you want? The matter is over. We put this affidavit that in terms with this, you will be granted the benefits. This is the claim you have made in the writ petition. What is your claim in the writ petition? Why it is 66 lakhs you are asking?
He is entitled for more than that, Lordship.
Huh?
He is entitled for more than that. What he has asked,
She has got some money.
no, he would do not want, as per the trans policy, he probably he wants the money.
No. Why is she asking for 66 lakhs? Not entitled.
No, he is entitled for more than that because when it will be a recurring cause of amount will be 37 lakhs if added, Lordship, till 20, from 21 to 50 lakhs he will get after that. After 100 years, he will get the 50 lakhs. And he is in every year he is entitled for 2 lakhs, 2 lakhs 75 plus 23 lakhs he is entitled for. So till today he is entitled for 30 lakhs, 37 lakhs, and till every year he is entitled for 2 lakhs until 100 years. Until 100 years. Thereafter, Lordship, the maturity amount of some assured of 50 lakhs he will get or his nominee will get. After that, or 100 years. After 100 years. Is more than that he is entitled.
Yes. 100 years people don't survive.
Then before that, on death he will get the 50 lakhs.
You do one thing. We have it on Thursday. You show it to your client whether he's okay with this. Okay? Don't think about your senior. You appear. And if your senior appears also, we will not conduct a matter. We'll adjourn this signer that till you don't appear. Okay? In appearing will not help. Ms. So-and-so who appears on behalf of the petitioner submits that though the respondent's central, what, LIC?
Yes.
Had filed an additional affidavit in pursuance to the order passed by this court on 14/5/2026. But she yet to obtain the instructions from her client as regards the amount so stated in the said additional affidavit. She therefore submits that let the matter be listed on Thursday so that she can take the appropriate instructions. List the matter on Thursday. Yes, it's an interesting case.
There was an order passed by this was on 12/5.
The PWD, na?
PWD has not filed the affidavit till date. Although they have controverted to our stand,
No,
but they have not filed it
no.
yet.
If they don't file, we go as per that particular document, whereby they have adopted your stand. The
Yes.
issue letter
Yes, yes.
is what they have.
No.
So they, unless any action is being taken against the chief engineer by a higher authority, the PWD will say, and the higher authority of the PWD have instructed the PWD to say something else. It's a different aspect. Anyway, let's see.
Mala, there are 3 dates which are very important for adjudication of this matter. 18/12/2025, where your lordship will find at page 275. There were 7 bidders. Out of 7 bidders, 5 was technically non-responsive and 2 were technically responsive. At page 275. Now, The thereafter, they decided to open the financial wing at page 277. Please see my note 2 technically responsive. I am number 2, which is a petitioner, and 5 was
No,
technical.
Mr. Das, the only question,
Only,
if I'm
yes.
not wrong,
Correct.
is whether what has a say in the technical evaluation.
Correct. And secondly, your lordship's query was that what is now the mot, whether they have a say in the technical, whether their person was involved so far as while opening the technical. Now I'll show their mot person was involved in the opening of technical way. Because as per the circular issued by them, which they have annexed in their affidavit, clearly shows who are the person who has to be there. And what is the role of those persons.
But what person was not there in the
Yes, yes,
financial?
of course, it was there.
In the financial, it was not there.
I'll just show, I'll show before this court.
Show me as regards the financial people here.
Please see. If the lordship looks at page 372. First, your lordship will see the last minutes. Please see the last minute, which is 283 minute. Please see 283.
Going to which page?
283, my retribution line first. 283. Now, if the lordship looks at 281, this is the last minutes of meeting. Prior to that is one on 9-1. After 275, 278 is a 9-1-2026. This 9-1-2020 relevancy, why? Because
Wait, can you come to which page
No, I
you are
just
referring
show-
to? You are jumping.
no,
Mr.
no. I'll show first. Let's see my lot 275, which I addressed to your lordship.
First, let us-
275.
Yes.
18-12-2020. This is if your lordship with the
Online.
online.
বস্তু আছে নেকি? মাৰ্কাৰ কিবা আছে নেকি?
Now,
হালধীয়া highlighter নাই নেকি? এইটো অৱস্থা ইমান বেয়া। Yes.
please see the Roman 3. The online technical will open on so and so of
This is 1812.
1812, right?
So 1812 is the
The
first.
minutes for technical redevolution held on 1812.
Then
Now, if you see, these are 276. There's an evolution of so and so at page 276. And if your lordship looks at 6, please see 6. Rana Construction annual turnover certified by chartered accountant does not match with detailed furniture in Annex 3. Labor license not valid as on due date. Hence, the bidder is liable to be declared non-responsive, so and so. But if your lordship looks into UCN, qualification information submitted, bidder is found to be ordered as per so and so.
which one?
Is 7, number 7. There is a petition. Is a petition. Qualification information submitted by bidder is found to be ordered as per.
There were two persons who objected, na?
One is Vidas and one is Rana Construction.
Vidas is number 2.
Yes.
Complete information is required under 6 has not been submitted in so and so further the annual turnover certificate of the does not match with Annex 6. Annual turnover certificate does not match with so and so document to evidence that Annex 6. So you are responsible.
Now I am responsive, but please see the last paragraph. A representative of RO, Gauhati was present in the meeting and opined that in case of bidder of Sanjay Kumar Singh Rana Construction, UCN Construction, where certain disseminate documents submitted as like PG and POA, UCN Constructions, so and so. So they said there was some minor discrepancies so far as the UCL is concerned. Now, if your lordship looks into these are minor discrepancies,
Where is the minor? Where do you get the word minor there?
please see 273.
Yes, where?
The minor,
Where is the
these are
minor
because-
word out there? There are
Yeah.
certain discrepancies.
in submitted PG and
There's a
QA.
difference with that.
No.
With the
I'll show why
minor-
I'm minor. Why
It is certain.
No, why I said the word minor. My lord, if your lordship looks at 270.
No. That is the interpretation. That is for them to decide.
No.
I am only saying here, they put the word certain.
No,
Once
they
it
are
is put
relying.
certain, it is different from minor.
No, they are relying on page 273. That's why I'm saying, madam. Please,
You
if your
find that the
lordship,
chairman may take a decision. Who is the chairman?
chief engineer,
And opine that the
PWD.
chairman may take a decision upon requesting for clarification in order to increase participation in the tender. And therefore, he says that all the chairman will be who?
chairman is like my devolution committee. Chairman,
A
chief engineer.
Okay,
Chairman.
so he therefore delegated it to the chairman.
Yes, correct.
Find that since the discrepancy in the documents of so and so were minor, now
Yes.
he says minor
But it is guided by 273. Please see 273.
only, and hence were considered technical as per so and so. However, in so and so as well, here the labor license is found to be really invalid. And there is a mismatch between annual turnover certificate issued by the CA and so as regards turnover, and hence additional were not sought for so and so. So therefore, Rana Construction as regards the labor license and so and so. Then
My 273, please see my stopping 273. 273. This is the Ministry of Road Mark. And please see my lord. See my lord. Guideline for evolution of each fee. So this is why they said minor. Now please turn to page 270.
C and D.
Yes, right, minor.
Minor deficiency in certificate submitted against claim for technical or financial capacity.
We are
So
saying minor.
here,
No, so for
the
a UCL,
discrepancy between, no, my question is, the discrepancy out here for Rana Construction is that the annual turnover certificate issued by the CA and Annexure 3 as regards annual turnover. There is some discrepancy.
labor license, yes, it is misplaced. Which if it is misplaced, cannot-
Mismatch.
mismatch, then what you cannot submit an additional document. You cannot submit an
You
additional.
can very well
document.
ask for clarification as per this. Minor
No,
deficiency in certificate submitted against the claim for technical capacity. Technical deficiency like specification here not so and so. Certificates here share of JV partner not mentioned. Category of work claimed by the bidder and financial deficiency like turnover against consultancy were not mentioned there. These are the things.
Yes.
Then
Now, my lord will kindly see at page 278. They received, my lord, representation, the ministry received representation on 3/1/2026 and 6/1/2026. Now, please find in view of above, my lord will kindly see. So as in view of the above, it is not decided to open the financial bill. Meanwhile, my lord will kindly, representation were received from technically non-responsive bidder, namely Midas and Rana Construction, requesting reconsideration of their technical status. Further, Rana Construction Engineers has also raised complaint against the technical responsive bidder Sanjay Singh UCN. After detailed discussion, the following decisions were taken. Rana Construction in the reputation letter dated 6/1 raised objection regarding non-fulfillment of so and so, Sanjay Singh and UCL. Upon examination at 279. Upon examination, the bid evaluation observed Rana Construction themselves have not mentioned the name of the work integrated platform. Similar minor errors were observed submission of some other bidder. As the integrated pack provided in the RFP is a draft and form of part of contract agreement to be executed by the successful bidder, BEC decide to ignore such minor formal deficiency, which can be rectified at the time of execution of contract agreement. Accordingly, decide not to seek any clarification of any bidder on this issue. From other point raised by Rana Construction against Sanjay Singh and UCN, BEC decided to seek clarification of two bidders and decide to allow them 3 days time to clarify their stand from the date of issue of the letter from Chairman BEC and decided failing of submission of clarification within stipulated time will make them technical non-responsive. Further, BEC not to accept any additional document with the clarification. So this you'll find at clause 28.4 minor. 28.4. Rana Construction in the representation letter on so and so, except that they have submitted invalid labor license due to human error, which VEC decided not to accept. Hence, Rana Construction technically non-responsive cannot be altered, and there is no point arises for seeking clarification regarding other ground for disqualification. VEC viewed the repentant receipt from Managers Construction, re-examine a technical bid, documentary evidence related to hot mix so and so, so and so, so and so. This point is found to be ordered and is hereby accepted by VEC. 5. Midas has removed column and table related to bonus so and so, and in annexure to technical bid is not mentioned, wherein a turnover in inclusive actual GST which does not clarify the mismatch in value of turnover in fee turnover certificate in Annexure 3. Further, while re-examining technical bid decision has been observed, documentary evidence submitted by machinery so and so. Now, my lord, will continue. Further, we decide not to accept any additional document visit benefit. Now, all this BC, the committee was present. Chairman, my lord, will kindly say representative of regional officer, he was also present at page 280.
Yes.
Page 280. All these committee members and
No, that is okay. Now, why do we have another minus on 281? 281?
281. My lord, because the financial bid has to be opened up.
But this is for minus for technical bid.
Technical bid, because
Page
they,
281.
yeah, because why? They sought for, because they filed a representation before the ministry, like Rana Construction. So they directed a BC to consider. So they did not open the financial bid. The opening of the financial bid was done on 21/1, which your lordship will find at page 281.
When we come to page 282, in the BC meeting dated so and so, it was decided to seek clarification from bidders so and so and so and so. And also decided to allow them 5 days to clarify their stand from the date of issue of the letter from the chairman BC and decided failing with so and so within the year technically non-responsive. In the BC meeting, it was further decided not to seek any clarification from so and so as they accepted so and so. Within the stipulated time, clarification has been received from so and so and so and so, and the bid evaluation verified and examined the valuation of the demand. Sanjay Singh, Vitas, Promotional, we are concerned. Qualification information submitted is found to be ordered as per the stipulation. And it means you are just again repeating.
Yes.
In view of the bid evaluation, finalize the names of the technical responsive and non-responsive bidders are depicted in the table for evaluation of the substantial responsive. Here also you have the representative. Yes. He is also there. Yes. Then what happens? Then thereupon the representation goes to the court.
No, it's representation first, they file it before the ministry first. If your lordship looks into, now please see that the ministry chief engineer. Lordship. My lord, kindly see 333, my lord, for a moment. Please see 333, my lord. 333. Epidemic of the moth. Epidemic of the moth. 333. 333. The 7th of January 2026. This is addressed to CPG.
No, no, I'm not there.
No,
My question is,
You're not-
no, Mr. Das, my question is, whether the evaluation was carried out on 21/1/2026 by taking into consideration the representation submitted, which was forwarded by Mott.
Yes, that's
Where
what,
is
that's what
it?
I'm saying.
Now, where is
See,
it mentioned?
This 333,
No,
this
no.
was forwarded by more.
No, no, you are saying about the date, but
No, I'm saying about the representation which has been filed by Rana Construction to the Mott, saying that this is what has happened. Whether your lordship is asking now to me, whether this representation was sent to BEC for consideration or not. That's
no,
what,
I'm asking whether in the minutes of the meeting,
yes,
which were there in those two minutes of the meeting, one is 9/1 and one is in 21/1.
yes,
The bid evaluation committee
yes.
or the technical bid evaluation committee consider the representation in the
I-
light of that.
Right, that's what I am showing it, my lord.
Where?
Please see 9/1 at page 278. See, my lord, in view of above,
Representation were received from technically responsive so and so requesting reconsideration, other so and so. No, but here they don't say that it has been forwarded by anybody.
no, this had open responsive on 7/1/2026.
Understood?
Now,
My question is, meanwhile, representations were received from technically non-responsive
yes,
bidders, namely so and so requesting reconsideration,
yes,
so and so. Now, they have thereupon sent it upon representation has been looked into. So in the representation, they have raised dated 6/1/2026.
and C1.
Where is the representation?
Now, please see, this is not with us, my lord. Representation is not with us.
Date. Is dated 6/1/2026. So this is it. So therefore, this is being submitted and they therefore they are referring to their representation number, this one. Okay, so therefore this representation was considered. This is the representation. So therefore 396 is seen the number, file number 722-5355. And here 278, they are referring to this representation. Okay. Now thereupon the minutes again is held on 21/1. Now what has that changed in the
Now-
meantime is this matter again goes back and on 21/1. Now finally come to page 287.
287,
Paragraph 6.
287,
Yes, paragraph 6.
paragraph 2. Now, before that, can I just one, with your lordship permission? But 282, can I just point out the 6 while deciding the 21/1/2026?
Yeah.
Please see 6, Rana Construction. The annual turnover certified but does not match with detailed furnishes labor license not valid as on the bidder submitted additional documents in support of the same, and the same was not accepted by BEC. Hence, the bidder is liable to declare non-responsive as per clause 4.2.
That I understand.
Now,
This-
labor license,
They're similar.
My lord, with fairness, I will submit before your lordship. Labor license is not the subject where they can reject it. Labor license. During the period of contract, suppose there is an agreement which is executed, Rana got it, then he can submit a labor license.
No, there are judgments. On labor license, there are already judgments.
There cannot be the ground.
Now therefore, let us see page 287.
And your lordship 283, the repentive was also present.
Ah.
Now please.
So therefore, in those three meetings, 18/12,
9/1,
9/1 and
21/1,
21/1, these three meetings, the representative was present.
Mott.
Mott.
Yes.
The representative of Mott was present.
Correct.
So he was of that view. Now, but he was not present while the financial evaluation was done.
And whether the PWD, the DEC, whether informed to them, whether the financial bid was.
Whether inform is not the question is whether without his presence, financial bid could have been opened.
Now I'll draw your. No.
Now therefore come to Mr. Das,
286.
287.
87.
Yes.
Yes.
Paragraph 6 is labor license.
Labor license, that's my lord, that's me.
Now kindly see paragraph 7.
Paragraph 7. Ministry circular dated 16/1 to the permit seeking and considering clarification of minor procedural deficiency that to alter the basic character of the offer and do not result in material change. Circular emphasize uniformity and fairness in evaluation and avoidance of rejection of non-material procedural ground. The issue of minor deficiency was raised by the representative of RO Gauhati during the evaluation meeting on 18/12 and also Rana Construction dated 6/1/2026 with specific reference to the above circular. Opening of financial bid upon receipt of representation and initiation of examination at the ministry level, it was advised that the financial bid should not be acted upon pending examination. However, RO Gauhati informed on 4/2/2026 that financial bid has been opened by state PWD on 3/2/2026 without prior knowledge of RO Gauhati, despite pendency of examination at the ministry level. So what they were saying, they saying that without prior knowledge, this was open. Oh, that's what they-
Let us not use these words as an elusive theorem.
No, this is not.
No,
elusive,
no,
this is-
no. You see, the thing is, whether for the purpose of opening of the financial bid, there is a requirement of the ministry's representative to be there or
It
not.
is not required. That's my straight answer, my not required. Why?
Let
Why
us see.
it is-
Let us now see the constitution of the community.
Right, correct, man. Now, if you see, my lord, there, if it 307. 307.
Yes.
Now, 23rd of February 2018, Constitution of Committee, your lordship will find at page 309.
Yeah.
And if your lordship goes down 8.2, evolution of 8.2, works with sanction cost of civil work more than 5 crores to 100 crores. Opening and evolution of it shall be done by the evolution committee with composition and mentioned in the following table. So these are the composition. Chairman is the chief engineer. Representative of state is the member. 310 minor. Deputy secretary, officer nominated member, superintendent engineer member.
So
and
number 3 is that what
Moth is, yes,
is there?
yes. Yes, moth is there. So now, please start.
So the financial bid opening could have been done without the mot.
Now, moth is there. Now kindly see 311. 311. Acceptance of bids. My lord, 9.2. Works with sanction cost of civil work of more than 5 crores to 100 crores. Authority to accept bids having tender premium with 5% of sanction cost of work. Tender based on recommendation of evaluation committee mentioned in table 2 and for carrying out all necessary contractual formalities leading up to signing of the contract agreement in a time bound manner shall be not below the rank of principal secretary, secretary of the state PTA equivalent or any officer not below the rank of so and so. Now, please turn to page 312. At issuance of letter of acceptance award of LOA 10.2 works with sanction cost of civil work of more than 5 crores to 100 crores. LOA shall be issued by the appropriate authority, not below the rank of superintendent engineer. Thereafter, the contract agreement shall be signed by the appropriate authority.
But the question is, here could there be a financial bid opening without the mot
My
representative?
lord, representative was present by forming a committee of a BEC, bid evaluation committee, where my
Whether
lord-
BEC would not constitute the financial evaluation.
No, BEC will do all.
So
Not
therefore,
Yes,
in absence of the mot's representative,
yes.
would the person concerned, would the bid evaluation could at all have been taken into consideration?
Can I lordship take to 372? The answer I'm giving 372. Please see 372. Please see paragraph. Para 6, kindly see my lord. Para 6, my lord. Para 6 at page 363. Page 363, my lord. Affidavit by chief engineer. Affidavit by chief engineer,
Who has filed it? Certificate?
chairman of the BC. Please see paragraph 6, my
So
lord.
this is being filed by the state.
Yes, correct. Now I'll say what is state clarification.
Why,
Six,
why somebody was saying that the state has not filed?
Your paragraph 7, my lord, which you have that affidavit. My lord, please see, I am saying 6, then detailed
Please see
response
six.
has not been. Sir, that I'm giving an answer to my lord.
Yes.
Must see para 6, that in paragraph number 16 of the said affidavit, respondent who has submitted that at the financial period opened during the pendency or examination at a ministry level and without prior knowledge of RO Gauhati. However, the deponent begs to state, matter of fact is that after a telephonic conversation with RO Mott, Chairman PC finalized 3/2/2026 as the date of opening of financial week. Accordingly, an intimation letter dated 2/2/2026 was issued by Chairman PC to all PC members informing about the scheduled opening of
No,
financial.
there is no quarrel with that.
Which was
No, Mr. That there is no quarrel with the fact that you intimated by the communication dated 2/2/2026, it was intimated. My question is whether a financial evaluation could have been done in absence of, or can it be done as a quorum?
Yes.
The quorum being over. Whether any notification is there to the effect that the quorum would be sufficient.
Yeah.
That's it.
No, my lord. This is-
Tomorrow, just for example, the chief secretary, the chairman is not there. Can you have the BC done?
No, here I am, what I am saying, that people lordship looks into was duly emailed to RO. Now,
Absolutely
So
understood.
suppose I.
No. It is, you see, one thing one have to understand.
Yeah.
This PWD is carrying out this work
Yeah.
at the instance of
Correct.
Mott.
No, right.
No. It is at the instance of Mott. Now, Mott has said that certain amounts, which is from 5 to 100 or
Yes.
0 to 5, we are not going to look into it. The above 100, NHI, DCL, or all these people will look into it. 5 to 100, let the state PWD look into it. This is how it is. But then also they have set out these guidelines.
Correct.
Now, my question is, without the representative of Mott being present, can they not say today that you did it without this, and what right you have as a petitioner?
Then can I give an answer? Yes. It will be a case where the state would not have informed any about this incident, about opening of the financial week to the mall. It is not a fact that it was not informed. My lord, the case would be on extreme that if it would not have been informed to the mall, then the situation would have been different, my lord. Now I informed to so and so. It has been informed to mall. It is not the case.
Mr. Das, it is not you. You are not there. Unless you are saying that you have any hand with the PWD, I'm not on that. No. But my question is, you have nothing to say. It is between Mott and PWD.
Right.
You, therefore, a quorum or a technical or financial evaluation be carried out without the Mott being present, they have a right to say that.
No. Kindly just, I am giving a reply because your lordship is putting a query to me. My lord, I'll please see 372. Last slide, please see 372, my lord. 372. Letter by the state to the regional officer on 2/2/2020.
Therefore, I'm saying that there is no question.
Because
Mr. Das, there is no question with the fact that you, PWD had duly informed Mott. There's no question. There's no denial to the fact. But the fact that the Mott representative was not there. Now, could you have proceeded with it? Now, at your instance,
Can I
no,
say
therefore,
that?
I'm saying, therefore, at your instance, whether this court should entertain a fight between both of them.
No, this I'm not saying. But my instance, it doesn't mean, my lord. What about the Rana construction? Please see their particular, it doesn't mismatch. So technically they are disqualified, my lord. Technically they have come to the court now today before the My lord, your lordship is right. I cannot say anything about between the moth. That I fully admit. I fully admit, my lord. It is moth and between the state. I came up before this court only on the ground that technically I was responsive on the basis of the repentation which was filed. That was considered on record by BEC. On record by BEC. So BEC, in as per the circular, BEC was constituted. All these repentance was present, and thereafter they have taken it.
So so there's
This
no
is what
problem
was there.
No, Mr. Das, there's no problem with 1812-9-1-21-1. There's no problem with that. Now the fact remains that this is an internal matter between Mort and them of the PW. Now the Morts, as per the notification on which PWD gets the jurisdiction to get this work done through them, they categorically say, look here, we have one representative of our person has to be there in the BEC, which will include the technical or as well as the financial. It's a two-bit system. Admittedly, this person was not there. Now look at your situation. You have been found as given a particular rate, which is found to be the most favorable rate. The other persons are not concerned to that effect and what you mean. But the fact that as of now, you have not been even issued a letter of intent. What right do you have? You can't have any right to that. Yes, on the face of it, the Mort person was not there. You can't, there's no, even a
That-
case where a letter of intent is being issued also, Supreme Court has categorically said that you don't have a right unless there is a letter of acceptance. It is said by the Supreme Court to be an embryo.
But I am arguing on the basis of those documents which are put. Your lordship can ask why this is between moth and within the state. What has been done and why they have done it. Whether that your lordship will definitely ask them. My case I present.
No, the question is, the state PWD
Yes.
duly accepts the decision of Mott. And accordingly, they go ahead. They say they have cancelled it. That is why you have come.
Yes, correct. Right.
So the state, so now, yes, the fact they also recognize one thing. Kindly, therefore, I'm saying page 287, paragraph 8 is relevant.
1 second.
287.
Yes. Yes.
So therefore, these are the reasons on which we are, the question of judicial review is required or not. So first, 80 says that the financial evaluation was done without, in the absence of the Mott representative. Nine, kindly come to 9.
Is 8 your lordship?
9, 8 is, 8 in, says only to the effect that a financial evaluation is done without the Mott representative
Right.
being present.
Right.
On consideration of the record, it is noted that the issue of treatment of minor deficiencies
Yes.
and the approach of seeking clarification was raised both during the evaluation process and through representations with specific reference to the ministry circular. The record reflects that the approach to the clarification was not uniform across bidders. It is further observed that the labor license requirement as structured is placed as an execution stage compliance and not at the bid stage qualification requirement under clause 4, nor as a parameter for determining the technical responsibility under the bid evaluation provision. Even otherwise, being a statutory compliance relating to the engagement of the labor during the execution of the work, it does not pertain to technical specific capacity or financial qualification. It is also noted that the financial bids were opened during the pendency of the examination at the ministry level and without prior knowledge of the RO, and that both technically bids were also above estimated cost taken cumulatively. So therefore, these are the two reasons.
Correct.
One is primarily on the ground of labor license, which you have stuck to that.
Yeah.
And the second is as regards the financial bid not being open. Now there remains another aspect as regards the pertaining to the thing which has been the discrepancy between the CS certificate as well as Annexure 3. That aspect is there. But the fact remains that these prevailed upon the ministry.
Yes.
to go for a cancellation of this. This is what it is.
Whether this is under judicial review, whether your lordship.
Why should
can
we?
enter. This enter,
They are the owners.
whether the lordship can enter. it.
Because you see the main problem I'm saying. Unless I compel by an order that they have to go ahead with that financial evaluation, which is very difficult for this court to ask. They would not release the finance to the PWD. You see, on the administrative side also, you need to look into it. You would not release the finance to the PWD. But look here. So therefore, I have to pass to that effect, that the amounts should be released. Now, therefore, they are categorically saying that we are not satisfied with it. They are the owners, actual owners of the.
Now, if technically it is non-responsive, their only grievance is that the financial fees, they were not present. Fine, that's the only grievance. And how could you open the financial bill without us? This, they can do it now also. They can do it now
I
also.
knew you are coming with that. Before
They
making
can-
that, I thought about that. The answer to that is you never know which was the ground on which they have come up out there and say that this is.
But here we check.
They
Not-
categorically say that a rejection of the labor license
I-
element.
Be obliged.
And why
But
should we
I-
now
I-
for
I-
this court to segregate,
lord,
which is
I-
the reason behind?
Lord, I am deeply obliged because what your lordship has spelled out, that what to the extent area of a judicial review. Now your lordship say, what is our area of judicial review? Will not, because the fund is coming from what? Who are you? Suppose we give a direction, that means we are compelling them. Now the question here is that, now they are aggrieved only by their representative not present in the financial. That's the whole case. But they also makes one mistake here, with greatest respect, which your lordship has said that so far as the CA mismatch with the annual turnover, that they have not looked into that aspect of the matter. That aspect of the matter was not looked into. Labor license is correct. That a judgment of this court also, that cannot be a ground of disqualification. That was, but what about the annual turnover, which mismatch with the certificate of CA? That doesn't spell out here itself in 288, my lord. Entire
Yeah,
order.
that mismatch, you have therefore had two documents out there. One of the documents were to the effect that you had the CA certificate and the Annexure 3.
Yeah.
If there was a mismatch, these were minor, it would come out within the minor definition.
That cannot be minor deficiency, minor.
No, no,
with
that is-
respect.
That is the
Then-
ministry's perception.
Then what? Then please see 4.83 then. Then that kindly see.
No, kindly come to this. Therefore, I am saying, kindly
If
see.
that is a
No,
minor
no, kindly come
deficiency.
to the 16/1/2017. The minor deficiencies in certificates submitted against claims for technical or financial capacity. This is being duly taken care of.
No, please see. My lord, please see that 6 kindly see at page 282. I'll just read 282. I'll not trouble 282. This is of 21. Annual turnover certified by the CA does not match with the details furnished in Annexure 3. Labor license number 2 is not valid. That's, my lord, cannot be a ground. Bidder has submitted, now please see, bidder has submitted additional document in support of the same, and the same was not accepted by EC.
So they wanted to submit later on, which was not
And-
accepted.
And now my proceeding. Hence, the bidder is liable to be declared non-responsive as per clause 4.42 of the RFP. So now please see 4.4 of the RFP. Is 53 plus C money.
Eight.
35.
E.
35. 4.4, 35. Please see that with, now please see 4.4 financial capacity. Now two kindly see bigger seller minimum average annual turnover up to date of the price level of year based on factors indicated so and so, so and so. Now please see, can we read this with page 74, my lord. Please see page 74, my lord. 74 annexure 3, my lord. Page 74 annexure 3. Now please see 75. Please see 74. This is annexure 3. Financial capacity of the bidder. And if you see at page 75, instruction, bidder shall attach copies. 1, 2, kindly see reflect the financial situation of the bidder. Numbers B, be audited by a statutory auditor. So these were the requirements. Now, when this first minutes of meeting was held, no additional document is not sought. My lord will kindly see at page 277. Please see 277. 277. Please see 277. However, the chairman opined at 277. The chairman opines in the discriminatory document in case of considered technically responsive as per ministry. However, in case of Rana construction as per documents submitted bidder, labor license found to be invalid, and there is a mismatch between the annual turnover certificate issued by CA Annexure 3 as regard annual turnover, and hence additional documents were not sought from the bidder and the bidder were considered to be known. So this was the ground. That was also one of the ground which was not taken into consideration by the ministry. They did not say anything. They were only harping on the labor license.
Okay, let us hear the other side because otherwise their clients will say, why should we have engaged you without you don't speaking anything at all?
I'm privileged to give an answer to your lordship.
So the previous order, my lord, has asked for the reasons, my lord, on the basis of which the 3/3/2026 order has been passed. My lord, I can standard noting, these are the key notings of the Ministry of Road and Transport, on the basis of which ultimately that decision of 3/3/2026 was taken.
Well, we're referring to paragraph 8.
Not first, my lord, I will be referring to paragraph 2.
That
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 is
is
yet
already mentioned in that document.
Yes,
You are coming to paragraph 8.
yes. In view of the representations received, the matter was discussed with the RO for proper examination.
And
Then
therefore, I
it was
think
directed that financial bids may not be opened till the matter was completely examined, which he further conveyed to the chief engineer, Malot NH Assam. And this was Malot conveyed white letter at page 333. Malot, Niksha 371/2026 letter. So my lord, the direction was, my lord, not to open the financial bid till the matter has been examined. Although, my lord, the bid evaluation committee can examine the, my lord, representations, and it was done, my lord, in the subsequent 2 meetings. But the direction was clear that no financial bid should not be opened.
but. Mr. Gupta, don't spoil your case. Till now, they are having a good, they don't have a case. Moment you are saying something, it's a case. And you see page 333, you are referring to that document. In this regard, it is requested to kindly examine the representation submitted by the bidder and to till you don't dispose of, don't open the financial bid. Then don't make that submission and to spoil your case. Now, coming.
My lord, the details of the
So
matter.
therefore, that document has no relevance to this meeting. Kindly see, completely which he further conveyed to so and so, detail of evaluation and relevant file were subsequently submitted by RO Gauhati through WhatsApp on so and so. So therefore, this matter was taken by the ministry level.
Yes.
Why you are referring to 333 and spoiling your case, ma'am?
Ma'am.
Yes.
Furthermore, while the matter was under examination at the ministry level, RO Gauhati informed on 4/2/26 that the financial bid had already been opened by the state PWD on 3/3/26 without his knowledge, and that he was not aware of the amounts quoted by the bidders. Thereafter, the undersigned contacted the chief engineer PWD telephonically, conveyed concern regarding the opening of the financial bid during the pendency of the examination, and short details of the financial bid. The chief engineer informed that the representation submitted by the bidders had already been replied to by the state PWD, and the instructions issued by the RO Guwahati, wide letter dated 7/1/26, not to open the financial bids till the disposal of the representation had been complied with. He further informed that the L1 bid was 4.77% above the estimated cost, and L2 was 4.98 above the estimated cost. It is observed that the clarification sought from the bidders pertain to non-material differences which do not reflect the technical or financial eligibility of the bidders, and such clarifications were accepted in respect of the two technically responsive bidders, whereas in the case of Rana Construction and Engineers, the clarification were not accepted on the ground that the submissions were treated as additional documents. It is further relevant to note that both technically responsive bids are above the estimated cost, whereas the prevailing trend of bids is invariably below the tendered amount, which prima facie raises concern regarding the fairness exercised in the evaluation of bids. In view of the above, RO Guwahati was directed to advise the chief engineer NHPWD not to proceed with the award till a final decision is taken, and the undersigned also conveyed telephonically to the chief engineer PWD Assam that the work should not be awarded till a decision is taken on the pending representation. Considering the totality of the facts and circumstances, including the manner of technical evaluation,
Yes.
then we are concluding, considering the totality of the facts and circumstances, including the manner of technical evaluation, the treatment of clarifications and the financial being which being above the estimated cost, it is felt that the cancellation of the tender and the re-invitation of the bids may be considered in order to ensure transparency and fairness. Now, Lord, then in note 3, note 2 may be perused in view of the fact that evaluation done by the PWD involves anomalies. We may cancel the tender and ask PWD to invite fresh tender. Then, my lord, note 4, I agree with the recommendation that considering the anomalies in the bidding process and the high price, the bid process may be cancelled and fresh bids invited. A self-speaking order may be communicated to the RO and to the state PWD. Although Director General Road and RD may address a DO letter to the Principal Secretary of PWD in the state government regarding opening of financial bids without the knowledge of the RO and anomalies in the bidding process. My lord, it is very clear, my lord, that the cancellation was made, my lord, because in terms of the ministry's notification at page 273, that very clearly says, my lord, that the clarifications which do not affect the basic character and profile of the offer be sought from the bidders. My lord, in that case, my lord, clarification can be taken, and those anomalies were of not of that nature, my lord, which would alter the basic character of the bids, my lord.
There's the recent judgment no, of the Supreme Court wherein it said that when one party is permitted to clarify or submit its documents in respect to the other, that person should be also given. Where is that?
Malad has also held in a recent matter. Who? In a recent BRO matter, but I'm not remembering.
For that matter?
Yes. It's a little clarification.
That you have caused the problem. And because of your problem, this is happened. Yes, Mr. Chaudhary?
Paragraph 7 also, Malad, I will just.
Yeah, I will just.
Just 2, 3 points I would like to highlight. Milord. First, my lord, so far as our perspective is concerned, we had a grievance. We raised the grievance. It has been redressed. So therefore, our matter ends there. Now, my lord, since on our complaint, the action was taken, therefore they have made us a party. So it is our duty to point out few things. First of all, my lord, the government of Assam in the PWD has accepted the order passed by the ministry, government of India. Now, once the government of Assam, the tendering authority who has, found him to be technically qualified and his financial bid was also processed. Now, where is the local standard of the petitioner, my lord? Basically, it is, if somebody is aggrieved, then it is the, my lord, state PW is aggrieved. Now, why I'm saying so, my lord? Now, thirdly, my lord, the writ petition has been structured on the basis that they have a vested right in view of the fact that they have been adjudged as L1. No, that is absolutely wrong. That's not the judgment below.
The Oasis.
Om Prakash Sharma. I think subsequent decisions are also there. Please come to para 30, page 195, Miller. In support of the said proposition, page 195, in support of the said proposition, learned senior counsel for the defendant, Rakesh Dwivedi has also placed reliance upon another decision of this court in so and so. The learned senior counsel has rightly placed reliance upon the judgment of this court in so and so. This being the settled legal position, the respondent acquired no right to claim that the auction be concluded in his favor, and the High Court clearly erred in entertaining the writ petition and in not only issuing a direction for consideration of the representation, but also issuing a further direction to the appellant to issue a demand note of the balance amount. Direction relating to issuance of the demand note for the balance amount virtually amounted to confirmation of the auction in favor of the respondent, which was not the function of the High Court. The law laid down by this court in the aforesaid paragraph in support of the proposition of law that so long as an order regarding final acceptance of the bid had not been passed by the chairman of the housing board, the highest bidder acquired no vested right to have the auction concluded in his favor, and the auction proceeding could always be cancelled. So, my lord, merely because he was just an L1, that will not bestow him with any right. It is only when a formal work order is issued, perhaps, my lord, it can be said that he has some right. So if that right is to be interfered with, in that case, my lord, the due process of law has to be followed. So here in this case, my lord,
Depending on the page 497 of the book. High Court ruling.
Yes. No, sorry, no. My page.
Ah,
What's that?
Mr. Chaudhary. Yeah, you're in, or, well, Mr. Das's clients are well-to-do. I would have understood the state saying that I have only got that,
Which portion, Millard?
that High Court.
The High Court erroneously thought that the government was bound to satisfy the court that there was collusion between the bidders. The High Court was not sitting on appeal against the order made by the government. The inference of the government that there was a collusion among the bidder may be right or wrong, but that was not open to judicial review so long as it is not proved, and that it was a make-believe one. The real opinion formed by the government was that the price fetched was not adequate. That conclusion is taken on the basis of the government expectation. Conclusion reached by the government does not affect anyone's right. Hence, in our opinion, High Court misplaced the ratio of decision of this court in various cases.
In fact, you see, most interesting aspect is what is asking the community to get this work done. These works are done on the basis of some DPR. Now, they fix a particular time. We go beyond that. What has a issue? The tomorrow, in fact, it is permissible for them to go ahead. Because that is what you find here. Also, mentioned in page 287 of the petition.
Yes.
As well as
It's a lordship that kindly come to page 21 of the writ petition, Millard, the very first page of the NIT. Point number 3, page 21.
Yes.
Bid through any other mode shall not be entertained. However, original bid security, etc. Please just keep that. Please come to last sentence. Please note that the ministry, authority, executing agency reserves the right to accept or reject all or any of the bids without assigning any reason whatsoever.
So the ministry is there.
Yes. Lord, if your lordship wants, I can point out the deficiency in the tender of the writ petitioner also, Millard. I think that we have pointed out in our representation, which has been taken over. Therefore, Millard, the matter boils down to here is a matter. There was something wrong in the process. There was a complaint, and authority has dispassionately looked into it and found that the allegations are correct. Therefore, Millard, the matter has been put to, and now it will be put to retender. Now, what is wrong in it? Whose right is? Everybody has right to participate again. It's
And whether court can exercise judicial review.
no. With great respect, Millard, this is not the area. To recognize a right of judicial review in a matter of this nature, Millard, yes, in an appropriate case, if it can be called out that this decision to go for retender was actuated by some arbitrariness or irrationality or illegality, that's a different area. But here in this, in my humble submission, Millard, it's an open and shut case. There were some irregularities which were taken note of, and it has been put to retender. I don't think, Millard, it's a case where a lordship would like to interfere. That's my humble submission. Lordship's kind permission, can I?
Yes, Mr. Naik.
In this application, lordship, I think my role is only to keep the facts straight, lordship, nothing else. Lordship, 5 points I am raising, lordship. What was the only restraint before the state PW department? It is page 333, that is lettered with 07/01/2026, and the restraint was do not open the financial bid till the disposal of the representation. That has been done. Lordship will note one thing, lordship, here. Representations were filed by one bidder. Representations were disposed of in a manner. And the person concerned who submitted those representations are not agreed now.
Obviously, you have taken.
No, against the decision taken by the, PW, state PW, he is not agreed.
It's a different thing because the ministry has already taken over.
Lordship. And the ground taken by the ministry, lordship, if lordship comes to that minute.
Are you saying that the grounds taken by the ministry
No, I'm only keeping the, trying to keep the facts straight.
I cannot permit you to make that submission unless and until you say on affidavit to the effect that the ground of the ministry is wrong, which you have not stated. Respondent number 6 has not
Okay,
stated.
we are bound by the decision of the ministry, but
No, no,
I
no,
am
so
still
therefore-
saying,
no,
I'm
so-
still saying.
No, you cannot, therefore, you hold the brief for the department here. And therefore, you are here to defend the action of the defendant. Now, of the respondent, PWD department. Now, the PWD department have said, have accepted the ministry's take. Now, if you are going to say that the ministry order is wrong, then you have to put it on the affidavit, which you have not. My only claim, because then it is very good. If you want, if the PWD
that-
wants.
that
No,
affidavit I have already
Mr.
filed.
Nayak, that
Affidavit
is
I have
also I
already-
say. Mr. Nayak, you can very well argue, only if you put it on affidavit that the ministry is wrong. Would the PWD for one contractor do that?
Lordship, in my affidavit, I have already stated.
Let us see your affidavit.
Lordship,
Have you stated the ministry is wrong? Then I can permit. Let us see the affidavit of.
Lordship will find one annexure.
Here.
At
Kindly come to annexure 6.
annexure 2, it starts from page 369. Now, before that, Lordship will kindly see the ground, Lordship, on which was the primary ground before the ministry, Lordship. That is at that 3 letter, Lordship. Page 287.
Now that I have read it.
Lordship, one
You see that.
their objection is that RO's representative was not there. Their ground was there without prior knowledge to us. So Lordship will distinguish between two.
We are not going to go on that. They have categories. Now kindly see, where have you mentioned out here that having the potential of creating misunderstanding and as such, according to the hearing, it deems that declarator for clarifying the stand. In paragraph 12 of the affidavit filed by respondent, I have submitted that upon representation of the response to the alert stated it was requested not to obtain the page. Which is you have given the clarification. It is also mentioned that after telephonic call that they adds the date for opening of the financial week. Accordingly, on intimation to him that it was done so. And informing him about the selected so which was duly emailed to the RO so. So two document is there.
Yes.
Then that in the employees have already held it because the deponent back to state that the cancellation notice have been issued as per the direction of so. So therefore, you have accepted that the ministry has the power to issue that direction.
That we are. But only the fact, Lordship. One fact, Lordship, is, I mean, that point, Lordship, whether RO's representative was there or not.
He was not there.
Lordship,
He
without,
was duly informed, but he was not.
Lordship, without RO's representative, we cannot even log into the computer. So RO's representative logged into the computer and thereafter the financial page were uploaded.
Show me that various statement.
Lots of that statement I have not brought, if I
You cannot make that the financial representative was very much present. You have categorically said we have informed. It will depend on.
Lots of. In fact, computer was logged into by a representative.
Then we'll have it at 2. Ask the
Lord,
chief engineer
one-
to be
one more-
present and ask him, take his statement.
Lordship, one more
Recorded
document,
on
one
the-
more document I am placing, Lordship. It's a subsequent document. This is 11th of May 2026.
Where
Lordship, one later. That is not there in the. Lordship, may kindly see this document. This was issued on 11th of May 2026. Lordship, may kindly read that.
the bid submitted by the speaker in a way.
Henceforth.
Including the chairman, within a.
So this was not a requirement.
Without the presence of members who shall not be in the bid.
This is one, that is the practice earlier. And second, representative was there. In fact, he opened the computer, he logged into the,
That is not your statement.
no, this, two points, Lordship. One, it's a notification of 11th May 2026. They are saying henceforth, without the presence of the RO, no financial tender shall be opened. That is one. And second, I'm submitting lordship. On that day also lordship, RO's representative was.
You cannot say that unless you put it on affidavit. When it is on affidavit, it is stated by them.
Lordship.
You cannot come up and say
RO was not.
he was not present. You make it in-
RO was not. RO was.
Where? Hey, that will be like. But she doesn't. Not four of where? Four things. We have a representation received the BEC held a meeting on so and so and decided to seek clarification. Oh, not four. Wow. I agree with the recommendation that transparency in order and also the DG may address a letter to principal secretary in the area opening regarding opening without the knowledge of area and the anomaly in the bid. I
The
think it was-
knowledge part lordship has already, even the date was intimated in that minutes lordship, RO himself signed that on such and date, such and such date, minutes are clear lordship. So he cannot claim that knowledge was not there.
No, you have put it, you have not said that.
Yeah,
You
I have
have
stated
Mr.
that lordship. I have
Mr.
stated-
Nayak, kindly come to this paragraph of your affidavit, paragraph number, page 362,
Yes,
the last paragraph. You have fixed after a telephonic conversation with this person concerned,
371.
362.
That is the statement.
That is your statement. And
Okay.
thereupon, no, Mr. Thereupon you issued that email on 2/2.
No, and the lordship may also perish 371. For a moment, 371.
Yes, where?
Last line. In view of above, the bid evaluation committee has decided to open financial bid of the technically
So
responsible.
there's a
bidder.
quarrel with that.
Lordship RO is there.
I am telling you now that 1812, 91 and 21-1, all these things, the RO is present and he has been a party to the decision.
So take the ground that RO was not there in the financial bid opening, but don't take the ground that he was not informed or without his knowledge, financial bid was opened. That is my submission, Lordship. Lordship, I have placed the, I have placed the recent document, Lordship, when the instruction was issued. On 11th May, that instruction was issued that without RO's present, no financial bid opening.
Are you saying that
So it
in
was,
earlier cases you have been doing it without the RO's presence?
that is the practice, Lordship. That is practice.
Put it on affidavit.
They never
We
object.
don't do that. Put it on affidavit of the chief engineer that you have been granting contracts, opening financial base without the RO's presence. Put it on affidavit. No, put it on it. He is already giving an interim order. You are being protected. No, put it on affidavit. Don't wait. Wait. That is, put it by a chief engineer. Don't make these submissions with the night just for the sake of it. Are you aware of making this, the effect of the submissions which you are making on behalf of the PWD?
No.
Is the PWD authority aware that you are opening up financial bids in without the presence of in respect to matters belonging to Mort?
Lordship, I am saying.
Can you make a submission? No, Mr. Naik, can you make a submission with such an irresponsibility for a department? Tomorrow, all these things will happen. Mort may take an action. I'm there for the PWD. What will happen to the state roads if the Mort doesn't make this payment? Just for the sake of one petitioner? Don't make this type of statement submissions with them. Don't make this type of submission. Anyways, let me come back. I'll dictate the order. Yes.
Dictate. Fight is between more than between the state. You don't want to lose any fund from north to state is also my group. Only what I want to I want to just project before this court is there. So far as the financial bill, if they're agreed, because they were present, let us say they are not present, it was mandatory they should have been. So only humble submission before this court. They from the stage where they were not present, that can be initiated again from the stage. That will, that may be mere irregularity, which may be recognized by them. That's my submission, man. From this stage, when they were, they
You
may
make
reject.
the submission on now on the indemnity,
I'm sorry.
on the indemnity bond which you have given.
Yes.
The matter have been pending for long now. If the price have escalated, you have given an undertaking, the repetition is missing. How do you take care of that situation? Think while I think. Because now this price is obviously going up. But on that day, what it was is different from today. Because the stay order was given on this day. 10-3, 11-3. So they will now take another 45 days for issuance of a new tender. There is a stay for them. So therefore, from 11-3 to will go to the month of July, if it goes, there will be an escalation to have to pay them in the month. Heard Mr. Gidas, the learned senior counsel, appearing on behalf of the petitioner. Its senior counsel is still by hearing on behalf of the which the H. Gupta appears on behalf of the respondent number 1, 8, and 4. Mr. P. Nair, the additional Deputy General, as well as standing counsel of the PWB, appears on behalf of the respondent 5 and 6. Mr. K. M. Chaudhary, the learned senior counsel, assisted by Mr. R. M. Detta, appears on behalf of the respondent number 7. None appears for the he appears for respondent number 8. The present petition has been filed by the petitioner challenging the order dated 3/3/2026 issued by the executive engineer for the Director General bracket R&D and Special Secretary, Ministry of Road Transport and Highway, bracket Zone Northeast, that is the respondent number 3, as well as the consequential cancellation notice issued by the respondent number 6, dated 9/3/2026. Next. Prospectus facts. The Ministry of Road Transport and Highways, bracket EAP zone, carries out various forms of works for construction of national highways. By the circular dated 23/2/2018, issued by the respondent number 4, Powers have been delegated to the chief engineer, that's regional officer, bracket CE dash RO, bracket 2, oblique SC dash RO, oblique PLO at Watch Regional Office. In terms with the said circular, the evaluation of bids circular. Sanctioning of detailed estimates and the power to grant technical sanction, appraisal, and approval to the estimate have been mentioned. How the evaluation of bids could be carried out is mentioned in clause 8 of the same circular. In respect to works with sanction cost for civil works up to rupees 5 crore, the state PWP have been delegated the power to evaluate the bids and finalize the tender as per the ministry's extent guidelines.
The lordship permission. Can have this.
In terms with clause 8.2 of the said circular, works with sanction cost of civil works more than rupees 5 crores to rupees 100 crores. It is mentioned that the opening and evaluation of the bid shall be done by the evaluation committee with the composition as mentioned in the same table. In the table mentioned as with the composition, with the specific, with a specific composition. Clause 8.2 of the said circular being relevant is reproduced herein under. From a table of the above clause, it will show that amongst the various members who are to be present, it includes an officer nominated by the CE-RO oblique SC-RO of MOT. Clause 9 of the said circular refers to acceptance of the bid. Clause 9.2 being relevant for the purpose of the present proceeding is reproduced herein under. Clause 10 stipulates who would be authorized to issue the letter of acceptance oblique award oblique LOA. Clause 10.2 refers to the sanction cost of civil works of more than rupees 5 crores to rupees 10 crores, 100 crores, and the said clause being relevant for the purpose of the present determination is reproduced herein under. It is very relevant to take note of. That the Ministry of Road Transport and Highways, bracket TAP zone, have issued guidelines for evaluation by the communication dated 16/1/2017. The contents of the said communication being relevant for the purpose of the present dispute is reproduced hereunder. Page 273, lecture. Next, in the backdrop of the above, it is pertinent to take note of, in the backdrop of the above, let this note deal with the specific facts which leads to the filing of the instrument petition. A notice inviting tender was issued by the respondent number 6, dated 17/11/2025, thereby inviting bids from eligible bidders from experienced firms of the organizations of appropriate class for operation and maintenance works. The work in question pertain to performance-based maintenance contract, bracket PBMC, bracket close, estimate to NH-127D, bracket from KM 19.000 to KM 48.600, bracket close, bracket open, length equals to 30.60 kilometers, bracket close, and 127A, bracket from kilometer 29.200 to kilometer 38.000, bracket close, bracket open, length equals to 8.80 km, bracket close, under Romania NH division in the state of Assam. Stop, bracket, total length is equals to 39.400, bracket close, bracket open, job number PBMC oblique 127A oblique AS oblique 120 2025 dash 26 oblique 286, page 21 of the. Amongst the various clauses in the said notice inviting tender is clause 3, which have relevance for the purpose of the present determination. The said clause 3 is introduced during that. From a perusal of the above clause, quoted clause, it would show that the ministry of the authority of the executing agency reserve the right to accept or reject all or any of the bids, BIDS, without assigning any reason whatsoever. In pursuance to the said bid, notice inviting tender, 7 bidders participated. By submitting their online bids. The technical evaluation was carried out on 18/12/2025. By the committee, which was constituted in pursuance to the circular dated 23/2/2018 and included the regional officer of MOT. In the said technical evaluation, which was carried out of 7 bidders, 5 bidders were found to be technically non-responsive. Whereas the petitioner and one MS Sanjay Kumar Singh were found to be technically responsive. The respondent number 7 and 8 in the instant proceedings were also found to be technically non-responsive. It is very pertinent to take note of the reasons were assigned as to why the respondent number 7 was technically non-responsive. The reasons were A. The annual turnover certified by the chartered accountant did not match with the detailed furnished in Annexure Roman 3. B. Labor license submitted by the respondent number 7 was not valid on the bid due date. It appears from the reports that pursuant to the said technical evaluation being carried out on 18/12/2025, the respondent number 7 and 8 both submitted representation to various authorities, including the regional officer, MOT, the representation of the respondent number 7 have been enclosed as Annexure A to the affidavit in opposition filed by the respondent number 7. The said representation is dated 6/1/2026. Wherein it was categorically mentioned as to why the respondent number 7 was technically responsive. It was also mentioned that the petitioner as well as MS Sanjay Kumar Singh were technically non-responsive on various reasons. By the same representation, their request was made by the respondent number 7 that the technical evaluation be re-evaluated by taking into account the contents of the said representation. The record reveals that on 7/1/2026, a communication was sent by the executive engineer for the regional officer Gauhati to the chief engineer to the respondent number 6, thereby forwarding the representations submitted by the respondent number 7 and 8 and place the same before the bid evaluation committee for appropriate consideration. In the same communication, it was specifically mentioned that till the disposal of the representations, the financial bids for the project may not be opened. In view of the said communication dated 7/1/2026, the bid evaluation committee comprising of the various officials in terms of clause 8.2 of the circular dated 23/2/2018 consider the representation submitted by the respondent number 7 and 8 on 9/1/2026. Upon due consideration by the said bid evaluation committee, it was found that the discrepancies which were mentioned for the petitioner were minor deficiencies. And the bid evaluation committee accordingly decided that certain clarifications be sought from the respondent number from the petitioner. At the same time, insofar as the respondent number 7 was concerned, it was opined in the minutes of the bid evaluation committee dated 9/1/2016 that the respondent number 7 had submitted an invalid labor license. And as such, the question for asking for clarification did not arise. Pursuant to the said decisions to taken that the petitioner be sought for, clarifications be sought from the petitioner in respect to the minor deficiencies. Such clarifications were provided by the petitioner, and in pursuance thereto, the same was again considered by the bid evaluation committee in the minutes of the meeting held on 21/1/2026. The bid evaluation committee, which again comprised of all the members of the committee, in terms of clause 8.2 of the circular dated 23/2/2018, again opined in the minutes of the meeting that the petitioner as well as MS Sanjay Kumar Singh were technically responsive, whereas the remaining 5 bidders, including the respondent number 7 and 8, were technically non-responsive. The records further reveal and more particularly from the affidavit filed by the respondent number 6, through the superintendent engineer, that there was a telephonic discussion between the chairman of the bid evaluation committee with the regional officer Mort Gauhati on the finalization of the date for opening of the financial bids. It was specifically mentioned at paragraph number 4 of the affidavit filed by the respondent number 6 that 3/2/2026 was the date fixed for opening of the financial bid in consultation with the RO Mort Gauhati. In addition to that, the respondent number 6 have also enclosed the communication dated 2/2/2026, which was sent to various members, the other members of the bid evaluation committee dated 2/2/2026, sent to other members of the bid evaluation committee, which included the regional officer Mott. As Annexure 3 to the affidavit in opposition filed by the respondent number 6. The said affidavit in opposition of the respondent number 6, however, do not state that the regional member of Mott was present in the financial bid evaluation, which was carried out on 3/3/2026. Though Mr. P. Naik, the learned additional advocate general appearing on behalf of the PWD, submits that without the presence of the Mott official, it is not possible for opening of the financial bid itself. The records further reveal that upon opening of the financial bid, it was found financial bid on 3/2/2026. It was found that the petitioner had quoted 4.77% above the contract value, whereas MS Sanjay Kumar Singh quoted 4.98% above the contract value. Subsequent thereto, the petitioner who were unknown, who had no knowledge about these aspects pertaining to the internal workings between the PWD and the Mott, was awaiting that the petitioner would be granted the contract being the lowest bidder, lowest eligible bidder. To the surprise of the petitioner could come to learn that the respondent number 6 by the cancellation notice dated 9/3/2026 have cancelled the entire tender process. On inquiry, the petitioner could come to learn that the said cancellation notice was on account of the order dated 3/3/2026 issued by the respondent number 4. It is under such circumstances the present writ petition has been filed. The records reveal that this court, by an order dated 18/3/2026, while issuing notice, passed an interim order that the respondent authority shall not initiate any fresh tender process for the same contract work till the next returnable date. The records further revealed that when the writ petition was again listed before this court on 24/2026, this court directed the petitioner to observe that the interim order can only be extended if the petitioner submitted an indemnity bond before the registry on 24/4/2026 to the effect that in the circumstance there is any escalation to the value of the work on account of the interim order passed by this court, and the petitioner is unsuccessful in the present proceeding, the petitioner has to undertake to indemnify the respondent authorities. The records further reveal that in pursuance to this court further granted time to the petitioner to submit the indemnity bond by 24/4/2026. In pursuance thereto, the petitioner submitted an indemnity bond before the registry of the court giving an undertaking and agreeing to indemnify and keep the respondents indemnified against any escalation in the value of the contract work arising due to the continuation of the interim order, if so occurs. Subject to the writ petition being dismissed, the interim order thereupon have been extended from time to time. In the meantime, the respondents numbers 1 to 4 have filed an affidavit in opposition, providing the reasons as to why the impugned order dated 3/3/2026 was issued by the respondent number 3. By the respondent number 3. The petitioners have also filed an affidavit in reply to the said affidavit in opposition filed by the respondent numbers 1 to 4, reiterating its stand in the writ petition and further denying to the various statements and averments The respondent number 6, as already stated herein above, had filed an affidavit in opposition, whereby the order dated 3/3/2026 passed by the respondent number 6, respondent number 3, have not been questioned. However, there were certain clarifications being given in respect to the said order dated 3/3/2026, stating inter alia that a regional officer of Mort were duly informed that the financial bid would be opened on 3/2/2026. It was also mentioned that the technical bids which were being evaluated were in presence of the members, were in the presence of the members who were in presence of the members in terms with clause 8.2 of the circular dated 23/2/2018. And in all these technical bid evaluations which were being carried out, the ministry, the regional officer of Mort was duly present. The respondent number 7 has also filed an affidavit in opposition, whereby providing various details as to why the petitioner was technically, whereby the respondent number 7 have tried to substantiate its stand that the petitioner was technically non-responsive, whereas the respondent number 7 was technically responsive. Various documents have been enclosed to the said affidavit filed by the respondent number 7, which includes the representation so submitted by the respondent number 7 on 6/1/2026. In the backdrop of the above pleadings, let this court now take note of the respective submissions made by the learned counsels appearing on behalf of the parties. Mr. D. Das, the learned senior counsel appearing on behalf of the petitioner, submitted that the technical evaluations were carried out by the committee which has been entrusted in terms with the circular dated 23/2/2018. The learned senior counsel submitted that when this committee had been delegated by the ministry to make these technical evaluations, and they having carried out the technical evaluation, finding that the respondent number 7 and 8 to be technically non-responsive, a further action on the part of the respondent number 3, respondent number 1 to 4, 2, 1, 2, and 3, to take any action for cancellation on the ground of technical qualifications, in the aspect of technical evaluation being not correct, was not permissible. The learned senior counsel further submitted that no doubt for the financial bid opening, the learned counsel further submitted that the records, as per the records, it appears that the regional officer Mort was not present in the meeting in the financial bid opening. On 3/2/2026. The respondent authorities could have the respondent numbers 1, 2, and 3 could have at best directed the re-evaluation of the financial bid, but not cancelled the entire tender process. It therefore submits that cancelling the tender process in the entirety would result in a price escalation which would not be in public interest. In that regard, the learned senior counsel submits that this aspect may be taken into consideration while this court is deciding on the indemnity so submitted by the petitioner. I took care of this. Mr. H. Gupta, the learned counsel, CCC, appearing on behalf of the respondents, numbers 1 to 4 submitted that the delegation which have been given to these authorities concerned, to the committee so concerned, in terms with the circular dated 23/2/2018 is based upon the evaluation to be carried out in terms with the extent guidelines of the MOT. He therefore submitted if the extent guidelines of the MOT, which in the instant case would be the guidelines stated 16/1/2017 having not been taken into consideration in the proper perspective, the delegation under no circumstances the delegate would be exercising a power not vested upon it by law, by the circular dated 23/2/2018. Anything more? Mr. H. Gupta further submitted that the reasons so given in the impugned order dated 3/3/2026 are reasonable and rational. The learned counsel, learned CGC further submitted that even assuming, for argument's sake, but not admitting, that the reasons are not to the liking of this court, but this court having been sitting in a being exercised, but as this court is exercising the jurisdiction of judicial review, such jurisdiction is circumscribed within the confines of the settled principles of law. Legal counsel for the learned CCC therefore submitted that the CCC that the order dated 23/3/2026 takes into consideration three aspects. First, the the member, the regional officer was not present in the financial bid opening on 3/2/2026, which is the requirement in terms with clause 8.2 of the circular dated 23/2/2018. Secondly, the reasons for rejecting the bid of the respondent number 7 on account of not having a labor license was too technical by the bid evaluation committee and the ministry, and more particular technical by the bid evaluation was hyper technical, in as much as the labor license would be only required at the time of execution of the work when the contract is being granted. Insofar as the deficiency in question the learned counsel submitted, learned CGC submitted, that in respect to the petitioner, the BEC had considered to be a minor deficiency, whereas in terms with clause 1D of the guidelines dated 16/1/2017, the deficiency for which the respondent number 7 was rejected also would come within the ambit of minor deficiency. In addition to that, the learned CGC submitted that the contract value in question have been already categorically mentioned in the notice inviting tender. However, if the bids of the petitioner as well as MS Sanjay Kumar Singh were taken into consideration, the bids are higher by 4.27%, 4.77%, and 4.98%. And if there was more participation in the bids, the value would have come down. He therefore submits that these are considerations, which forms the basis of the order dated 3/3/2026, cannot be said to be unreasonable or arbitrary or irrational for this court to exercise the powers under Article 226 of the Constitution. Anything more? No more. Didn't I say that? That is what I have said. The words, I may not use them. Mr. Gupta, I may not have the capability of using the words in a more proficient manner in which you want to put it. But then also, I tried my best. I think the division bench may help you. They are better in using words. Mr. Kane Chaudhary, the learned senior counsel appearing on behalf of the respondent number 7, however, submitted that the instant petition ought not to be entertained at the behest of the petitioner, taking into account that it is an internal matter between the MOT and the PWD. The senior counsel further submitted that what is the conceivable right of the petitioner in the present case, in as much as there is no letter of acceptance or work order have been issued to the petitioner for creation of a right. The Learned Senior Counsel further submitted that it is true that in certain circumstances, if the tender in question is cancelled in an arbitrary manner and arbitrary, unreasonable manner, coupled with malice in fact and law, it is permissible for this court to exercise the powers of judicial review. However, in the instant case where reasons have been assigned, this is not a case wherein this court may like to exercise the powers of judicial review. Continue. See, he is satisfied. Mr. P. Nayak, the learned Additional Advocate General, appearing on behalf of, as well as the standing counsel of the petition of the state of the PWD, submitted that the PWD authority do not like to contest the impugned order dated 3/3/2026. And this aspect would be seen from the fact that the respondent number 6 have issued the cancellation notice dated 9/3/2026. He, however, submitted that a perusal of the order dated 3/3/2026 is not in good taste, taking into account that the representative of the regional office board were duly informed about the opening of the financial bid on 3/2/2026. And in fact, it was with his consultation the date was fixed. Therefore, in the impugned order dated 3/3/2026, the manner in which the use of the words that the representative of the Ministry of Mort was not the regional officer of Ministry of Mort were not informed. And the said regional officer on 4/2/2026 informed the ministry about the said do not appear to be correct.
The second point was the ministry itself being a part of the decision-making process through RO lordship in deciding the technical bid of the private respondent. Subsequently, they were not expected to reprobate. That is the second.
Would you like to put it? Don't put it. I don't think you should wait without that activity. Because you have taken that action. Don't do that. If you do it, it would be. You see, I'm more worried about Assam getting better roads and money. And
Not
for that, I don't think unnecessary complicating your thing with Mott. Unnecessary for this. There might be at best a fresh tender. But for that to complicate your stand, I don't think minute PWD should do it. I would have understood if it was Mott. You are standing for Mott. I have to say, because you have to get the money. Main is the money. Anyway, let me come back. Active, slowly, steadily.
Lordship, with regard to item number 26, Lordship, we are filing a affidavit in opposition, Lordship. This record may be confirmed.
The facts narrated herein above, as well as the submissions taken note of, would show that the instant with petition, the dispute in the instant proceedings, centers around the question as to whether the respondent number 1, 2, and 3 had the authority to nullify the entire tender process by the impugn order dated 3/3/2026. And the additional question which arises, that is as to is if the respondents numbers 1, 2, and 3 had the authority, whether the such authority exercise of power was reasonable, rational, and in public interest. Additionally, it is all additionally another aspect which needs to be taken note of is as to whether the petitioner, as the whether any rights have been conferred upon the petitioner on the basis of being adjudged as the lowest bidder. The materials on record clearly show that the respondent authorities in the respondent state authorities have been delegated the power by the circular dated 23/2018 by MOT. On the basis of such delegation, MOT empowered the respondent authorities in the state to carry out, to initiate the tender process. But the question arises as to whether such delegation would amount to abdication of the powers of MOT, in as much as the settled law stipulates that delegation of power does not amount to abdication of the powers. It is also the settled law that if there is an abdication of the powers by way of a delegation, such delegation would be bad. Under such circumstances, it is the opinion of the court that MOT retains the power over the subject tender in spite of the fact that the state PWB authorities have been delegated the power to initiate the tender process. This court also finds it relevant out here to take note of the circular dated 23/2/2018. And in the previous segments of the instant judgment, this court have quoted clause 8.2, which stipulates as to what committee is going to adjudicate, to evaluate the tenders in respect to civil works more than 5 crores to 100 crores. The composition of the committee have been categorically mentioned. And the committee have been categorically mentioned in clause 8.2, which includes the officer nominated by the CE-RO/SC-RO of MOT. This court have also perused the tender document, from which it is apparent that the bid in question is to be the bids in question are to be submitted in two parts. First is the technical bid, and the second is the price bid. The bid evaluation committee so constituted in terms of clause 8.2 of the circular dated 23/2/2018 is required to evaluate, admitted on 3/2/2026. The financial bid was evaluated by a committee without the RO of MOT. Under such circumstances, the said bid evaluation, the financial bid evaluation, was in conflict with the circular dated 23/2/2018. This court also finds it relevant to take note of the reasons to assign in the impugned order dated 3/3/2026. This aspect this court is taking note of in view of the fact that the impugned order dated 3/3/2026 categorizes three reasons principally, primarily. First, that the tender bid, that the financial bid was open in absence of the RO of MOT. Second, the guidelines dated 16/11/2017, which have been quoted here in above, have not been adhered to. And thirdly, the bids which have been, the financial bids which have been, financial bids which have been accepted is 4.77% and 4.9% above the contract value, or above the estimated price. This court have already held that the financial bid opening without the presence of the RO mort was not permissible. In view of the circular dated 23/2/2018, and as such, the said bid financial bid evaluation cannot be taken into account. The question, however, arises on as to whether the bid evaluation committee, while carrying out the technical bid evaluation on 18/12/2025, 9/1/2026, and 21/1/2026, had gone against the guidelines dated 16/1/2017. This aspect is important, taking into account that this technical bid evaluation was carried out in presence of the RO mort. Clause Roman 1, small Roman 1D of the guidelines dated 16/1/2017 specifically mentioned that minor deficiency in certificates submitted against claims for technical/financial capacity, technical deficiency like specification of bridges not mentioned in the certificate, share of JV partners not mentioned, category of work claimed by the bidder, etc., and financial deficiency like turnover against consultancy service not mentioned, etc., are deficiencies which do not affect the basic character of the profile of the offer. And as such, variations of the clarifications should be sought for. In the instant case, a perusal of the minutes of the technical evaluation committee dated 18/12/2025, 9/1/2026, and 21/1/2026 would show that while the petitioner, while there were certain deficiencies in the bid of the petitioner, clarifications were sought for from the petitioner, and the petitioner provided those clarifications. However, insofar as the respondent number 7 was concerned, the deficiency pertained to as to whether was in respect to the discrepancy between the CA certificate as well as Annexure 3. This CA certificate with the discrepancy as regards the CS certificate with annexure 3 to the tender document have been construed by Mort in the impugned order dated 3/3/2026 to be a deficiency wherein clarifications could have been sought for. However, no such clarifications were sought given. No such opportunity was given to the respondent number 7. Further to that, the respondent number 3 in the impugned order have stated that the invalid labor license would not render the bid of the respondent number 7 to be bad on account of the labor license requirement as structured in table 7.1 bracket with first bid is required to be placed at the execution stage statutory compliance and not as a bid qualification requirement under section 4, nor as a parameter for determining the technical responsiveness under the bid evaluation provision. It was also mentioned in the impugned order that the said requirement of a labor license being a statutory compliance relating to engagement of contract labor during execution of the work, it did not pertain to technical capacity or financial qualification of a bidder and would not alter the substantive character or profile of the offer. It is very pertinent at this stage to observe that irrespective of the fact that the state PWD have been authorized to initiate the tender and a bid evaluation committee is being constituted in terms of the circular dated 23/2/2018. But Mort happens to appear the Mort in for all purposes retains the authority over the tender in question. This court at this stage finds it very relevant to take note of the judgment of the Supreme Court in the case of the F-Cons. And more particularly to paragraph number 15, wherein the Supreme Courts observe that it is that unless and until such construction of the contract appears to be malafide or perverse, the courts under Article 2 to 6 of the Constitution has to defer its decision to the decision of the authorities concerned. Taking into account the above, it is therefore the opinion of this court that the impugned order dated 3/3/2026 holding that the technical evaluation so carried out by the respondent by the bid evaluation committee was in conflict with the guidelines of MORT dated 16/1/2017 cannot be interfered with. Let this court now take up the third question as to whether the petitioner, whether any right had accrued upon the petitioner on the basis that the petitioner had been evaluated as the lowest bidder. In the previous segments of this instance judgment, this court have quoted clause 3 of the notice inviting tender, wherein it is categorically observed that it is categorically stipulated that the ministry, oblique the authority, oblique the executing agency, reserve the right to accept or reject all or any of the bids without assigning any reason whatsoever. In the instant case, it is seen that the reasons were assigned in the order dated 3/3/2026 cannot be said to be arbitrary or unreasonable or unreasonable. Under such circumstances, it is therefore the opinion of this court that the petitioner, being the lowest bidder, did not have any right, more so taking into account that the petitioner's bid more so account that till date, till the cancellation, till the impugned order dated 3/3/2026, as well as the cancellation notice dated 9/3/2026, there was no work order have been issued in favor of the petitioner. This could have also taken note of the considering the above, this court doesn't find the present case to be a fit case for does not find the present petition. Considering the above, there being no merits in the instant writ petition, the writ petition stands dismissed with cost quantified at rupees 50,000. We do one thing. You put a cost of 1 lakh, and that will take care of the indemnity. Because if I don't do the indemnity, question remains. Because otherwise they are going to create a problem. No, Mr. Das, if I don't put that in 50,000 and say that that should be the cover, take into account the indemnity is being taken care of by this 50,000. If I say that, otherwise they are going to create problems. What do you say?
The estimate will be prepared by the state PWD, but not by the ministry.
No, whatever.
No, I'm saying nothing, just giving an indication. Otherwise, estimates are done by the state PWD.
Doesn't find any merit in the instant petition for which the petition stands dismissed. Before parting with the record, this court, well, further takes note of that the tender notice was issued on 7/11, na? To Silent. On 17/11/2025. And the financial bids and the technical bids were opened on 18/12/2025. Thereupon, the financial bids were opened on 3/2/2025. It was only on 9/3/2026, after 1 month, the cancellation notice was issued. It is not that the petitioner did not have a plausible case. However, this court is not inclined to interfere in exercise of the powers under Article 2 to 6 of the Constitution, as this court is not sitting as an appellate authority. Further to that, this court have disposed of the instant with petition today, that is on 8/6/2027, 9/6/2026. And as such, there was no delay on account of the petitioner. In spite of the fact that there was an interim order passed on 18/3/2026. This court also takes note of that after the notice was issued and an interim order was passed on 18/3/2026, the respondents, this number 1 to 4, as well as the respondent number 6, have filed their affidavits only on such and such date. Under such circumstances, it cannot be said that the present proceedings have been delayed at the instance of the petitioner. In that view of the matter, it is observed that the respondent authorities shall not, on the basis of the indemnity bond, impose any amount upon the petitioner. It is 3/2/2026. Financial. It is not that I mentioned. And I interim order on 3 pro, not 3/2/2025. It is 3/2/2000. That day. If you. I think you better without the. Oh, this matter. Yeah. Is that the money? That's completely fine with about the. So how much is there? 12 lakhs?
Yes, ma'am. And then some odd, 32,000.
32,000 is 30. So we close the writ petition then.
12 lakhs, 32,835.
Now, heard Mr. B.D. Goswami, the learned counsel, appearing on behalf of the applicant, and Mr. R. Sinha, the learned counsel, who appears on behalf of the petitioners in the accompanying writ petition. Today, Mr. B.D. Goswami, the learned counsel, appearing on behalf of the applicant, had handed over a demand draft bearing number
500,171.
500,171, favoring the petitioner number 1 of an amount of rupees 12,32,835.
Being the final.
Which was the remaining amount payable by the applicant to the petitioners. A copy of the said demand draft is kept on record and marked with the letter Z1. It's the RC have duly accepted the said demand draft drawn on Sabade. Demand draft drawn on ICICI Bank. ICICI Bank. Value, Taking into account the above, nothing further remains in the instant proceedings. Nothing further remains to be adjudicated in the instant application, as well as the writ proceedings, accompanying writ petition proceedings. Accordingly, the instant application stands closed. Number two, the writ petition also stands closed. I know what to pursue. Also stands closed. In full satisfaction stands closed. As full and final satisfaction to the order dated 25/10/2023 passed by the chairman and member of the Real Estate Regulatory Authority, Assam. Next. This court further observes that in view of the satisfaction to the order dated 25/10/2023 passed by the chairman and member of the Real Estate Regulatory Authority, Assam. The proceedings before the Bakija officer initiated on the basis of the said order dated 25/10/2023 passed by the chairman and member of the Real Estate Regulatory Authority also stands closed. This court further observes and directs that the attachment of the immovable property of the petitioners belonging by the order dated 27/4/2026 is set aside. And consequently, the immovable property of the petitioner, which is the two-storied RCC building and the 3 rooms in the 3rd floor bearing dark number 1084 and KP Pata number 185 old, 800 new within Revenue Village, Rukmini, Gao, Moza, Beltola under this revenue circle is removed from any form of attachment. In respect to the present proceedings initiated against the applicant. The writ petition, both the instant application as well as the writ petition stands closed.
What's all? Deeply applied the lordship.
Yes, the last order passed by your lordship on 25/2026. No.
You are the main person.
Yes, Lordship. Just now I made a mistake. Like, I told some document. They have given the instruction. It is something as well. He says told Lordship. I had fallen my hand, Lordship. Sir. It told of documents.
Mr. B. Gogoi, you take note of the order yesterday I passed for the content matter. Though I've asked him physical in the open court, but I made it video conference. You asked him. And in the meantime, try to settle it up. Sir, you do one thing. You file an affidavit. The last and I think we may have to reply because have we given you a copy of this? Well, look at it. I think you may have to reply right without giving you an opportunity. Let them find it. When you see the ground for PhD, he says out here, then look here, the rule 12 or the various judgments of the Supreme Court does not say that it is district wise. It says about the neighborhood. And the neighborhood may encompass various districts also if he is there in those districts. It further says that as regards the house client, that he may not be there in the neighborhood of that, but it is contiguous. You are contiguous, no? It's a natural bound, natural water bound, which connects both the river, both the people. And as such, he falls in the neighborhood. So let this thing be brought on record by filing an affidavit.
Let them file an affidavit, we'll give it.
And you don't, you have to Don't say that I have got the records and all. It's not that I'm not filing next day. Because this matter has been taken up by me. So next time if you don't file,
I will file lordship. This time I will file. In fishery department, I don't have problem, lordship. We have staffs. In AFDC, we don't have staffs.
they don't pay you.
No, they don't. 220 employees is being terminated. The
Why?
lacking of staff in AFDC corporation. That is the issue. While filing it. In AFDC, not in department, we don't have that issue.
AFDC, no people.
No people, now going to the quick. 220 dismissed also.
But new service.
New service.
That's
If somebody is arrested, lots of things that happen.
But one thing good for you, you must be appearing for them for the bail.
I cannot, lordship.
Anyways, in pursuance to the order passed by this court on 25/2026, Mr. P. Sharma, appearing on behalf of the Fishery Department, has placed before this court a set of instructions. This court has duly perused those instructions, and it is the opinion of this court that the said instructions be brought on record by filing an affidavit, so that the petitioners herein would be at liberty, would also have get an opportunity to file a response. Mr. P. Sharma submits that the affidavit will be filed by,
By June last, lordship.
so that I can't take it.
No, you can, lordship, give me 7 days. No issue, I will file. 7 days, lordship, anytime. And I thought in the last week of,
Okay, let us do one thing, you file it by 22nd of June. We'll see thereafter, they will ask for time. On 22nd of June 2026. This is matter again on 24th of June 2026. At 2 p.m. Why 2 p.m.? They will ask for time for filing reply.
highly obliged.
The records which were produced by Mr. P. Sharma be again produced on the next date of hearing, which would be fixed after 24, after taking into consideration the stand of the petitioner to the affidavit so filed by the petitioners on 24 6 to come. You don't produce it now. That you third, you are there in the whole left space. The records which have been produced, we again produced on the next stage.
Filed a reply. I do not know.
See, how I replied that file so early. It was not possible to file till evening 4 o'clock here, 4:30.
Lordship?
It was not possible to file till 4:30 yesterday.
Yes, we got it with one copy. Gone through it cursorily, not so much in detail. What's important for me, right at the outset, Lordship, we have challenged the termination and the consequential encashment of the bank guarantee, which I'm not pressing. Yes, Your Lordship. But you may record my statement. We're not pressing that. And we'll avail appropriate remedies regarding that claim or any other claim other than debarment. Debarment is a public law remedy, so the writ is what we filed. Lordship has the copy of the reply.
Unnecessary.
Okay, Lordship, I rely on their reply to say that they also admit that the debarment is nothing but a necessary natural consequence of the termination, which basically means for the breach of the
My
contract.
question is whether there was a notice being given prior to debarment.
Lordship, prior to this particular debarment, no notice.
Because, madam, I am not going to touch on memory as regards the justifications of the. If they have not given a notice, let them give a notice and then they are going to proceed with them. And it's here.
It was good. It's 517 of the petition there also annexed.
If the notice was given, then the question comes as regards the
whether you
merits.
can at all, whether you can even with notice for a contractual breach, invoke debarment.
But you had been given an opportunity to reply. Did you raise the bona fide dispute?
Yes, Your Lordship. We replied, we wanted to close, there are documents in relation to the thing where we said, let's go close.
Which is the notice for debarment?
Lordship, the notice for debarment, there is a termination. There's a-
517.
Notice, the notice for debarment. Page 959. You have a copy of it or not?
That's not.
Okay. 950.
which is the same as 524.
517.
524. 5325. I think.
It is the notice of
525. Don't make a note of the name.
929 is the scope of duty.
It's 5325
And where is the reply?
at page 524 of the main petition. I do not like this annex again, but I have annexed my reply to them. This is the notice a year before the impute termination. And what is important is page 533 is what I will rely on.
524.
Is my reply, this notice.
This is the notice. Okay, this is your reply.
Notice, I've replied at page 524. Now Lordship turn to 523, 533, which is why I say this is not the notice relevant for this particular debarment order. 533. The dates are important, Your Lordship.
Now, what is your reply to the show cause notice? You have given us a reply. Let us see. We acknowledge the receipt of the AI issued by a response and we submit a reply investigating the light of the so and so. At outset, we reiterate our annual commitment to the executing the contract with so and so. Pertinent to highlight that the delays in achieving the goals mentioned are not solely attributed to our organization, but also have precipitated by so and so.
Relevant 528,
Delays
529.
on achieving in so and so, we shall be submitting so and so, delaying so and so in adherence to the blacklisting is an extreme punitive measure in so and so, without prejudice to the qualified share, unqualified commitment to the due performance of obligations on the so and so, to settle legal principles of the temple cannot be effected in market. Evidence of willful reporting so and so, the manipulation of the to the directive of the So you ask for personal hearing.
Yes, now Lordship.
Where is the personal hearing? And where is the order?
Come to page 533. Lordship, please.
Where is the order?
Lordship may come to 533. What transpires between this show cause notice, my reply, and this order is at page 533. It's in August. They waived the termination and they waived the debarment. And they say now ensure compliance and restart. There's a meeting held on 8/8/25.
So you mean to say that
This
in view,
notice lapses.
no, this written by whom? Elmont over.
Authority engineer. Lordship has page 533. You're at page-
Written by whom?
The authority engineer, this is there. They've written
But what is this? This is not, who has issued this? NHC
respondents.
has issued.
Respondents, authority engineer. It is
So
there on authorized.
you mean to say that in view of this document, they have foregone the show cause notice?
Correct. But that lapsed. They didn't want to pursue it and they said, now you continue.
But this is the different person who have issued.
Lordship, it's a respondents.
No, authority engineer is different.
Yeah. Are they disputing? This is there. It continued after that.
Authority engineer is there.
Authority engineer is different aspect. He and deputy general manager are different aspect.
Lordship, this authority engineer.
Lordship, the respondent.
Where the impugn order, let us see.
Person was monitoring it.
Where
And
the-
he then told us that no, forget the department.
We
forget the
observe
teacher.
that it leads to the rights only as well as possibility to the non. Sir. The efficient interest is- Where is the impugn order?
Lordship, that is at page 69, after a year of the show cause notice. Page 69. Sorry, page 81.
After all these things, you go back to 81. Notice of divan.
Lordship, at page 202 is who is the authority engineer. It is there on.
Yeah.
Lordship, on the same day, they first issue a termination notice, which is at page 69, and they follow it by a debarment notice.
Mr. Sekya, tell him. If you have gone ahead with that notice, I would have understood. That is not, you have not gone into the, you have made various allegations in your so-called notice. They have replied. Thereafter, what has happened is a different thing. You should have gone into a, you say that personal hearing will be given. Thereupon you take it up and do whatever maybe you say that the authority engineer comes up with all this thing. Very well, I don't go by as per what the authority engineer has said that he has given up all this thing. But you could not have just applied 23 clause. 23 one, na? What is that clause?
23, 24.
This is very difficult. I think you should take a decision on
25.
this properly.
There are certain problems which says term even when incomplete works.
Understood?
Opportunity has to be.
I am therefore setting aside this, giving you liberty to take action for debarment if you want.
The action has been taken, the notice has been issued, development notice.
No,
has
you
been
have not gone on that.
issued.
Kindly see this. See your impugn order at page 81.
Before that, the order of termination, there, the consideration has been made to the reply submitted by the petition. Termination order.
Very difficult. Very difficult. Oh, because you see, why I say so, kindly see your show cause notice. There's a reason why I'm saying so. Where's your show cause notice? Yes.
Lordship, read-
24
Otherwise,
to
it's page-
2025. Page, kindly come to page of the writ petition, huh?
5.7 is the resolution.
Okay. Kindly come to your. Yes.
Page 5.7.
Seven. No. It
And
is,
then finally they go on to 522 and then they say termination. in case the-
wait. What is this? This is 498. 498 is the so-called.
No, 5.7 is the super. Yes, that is the first round, your lordship. They first do an intention to terminate and then they, exactly the same thing. which they did
No,
here.
no, this one, 517, yes.
Yes.
Why I'm saying so, kindly see,
And
yeah.
then come to 528, your lordship. They mention the intention to terminate.
No. Yeah, yeah. Kindly come to 522 of the petition.
Yes.
Okay.
16.
Whereas notice for intention to termination as well as so and so for default have already been issued to the EPC contractor. However, taking into account the apex court's decision in one of the landmark judgments dated AI initiated dated so and so, and in the interest of natural justice, this show cause notice is being given. Now, you by yourself categorically say that in view of the Supreme Court judgment, you give up 23(1), which otherwise permits you to terminate, to blacklist as a consequence of termination. But then also you say at paragraph 16 that look here, irrespective of that, in view of the Supreme Court judgment in respect to this circular, we therefore issue a show cause notice giving you a hearing. In response to that, he has submitted a reply. Now, after that, whatever may be, what you have done is they submitted a reply on 17/3/2025. Then you terminate the petitioner on 3/20/2026 by allowing him to carry out and all these things. And thereupon, you go for this notice for termination, the department. And there you don't refer to anything.
In the termination order, it has been referred to. The
It is
reply.
good. You
It has
can
been
very well
taken together.
terminate. But you, on your own say, in this document, paragraph 16.
So therefore, that may not, notice
So
was
therefore, when you on your own say that these are the grounds on which you are going to do it, and then you are saying that I will give you a show cause to you along with a personal hearing. Thereupon she replies on 17/3. Authority engineer, whoever it is, he allows them to work, give them some work. He also keeps on doing work and all these things. Then one fine morning, after issuance of some notice may be issued for the termination, you must have issued some termination notice. Huh?
Termination, there's just a termination order.
Okay, so you have terminated. And a consequence of the termination, you have initiated that they are not on the basis of this notice. Problem lies there, man.
here. So first termination is concerned for that matter, intention to terminate. That notice has been issued to.
It's okay.
The reply.
No, she's giving up her termination. We are not on that.
In the
It's
report,
terminated. What? Huh?
in this spot, you're not
Wait, she's going for arbitration. She wants to do it in Delhi. Delhi, no? Because NHA, PCL all goes to Delhi to arbitration. That day I got hold of one matter of the Kohima. The interest because NHA, PCL does one lot of cases. So what has happened? Similar like this. Challenge is a very important thing. What has happened in that case? The challenge was made to termination along with something or some other area, but only the termination, but there was no amount being claimed as regards any amount which is payable to them. Something around 50% or 45% of work was done. Now, what would happen? The repetition was plea was taken of arbitration. The Leonard Coordinate bench dismissed the repetition. Then what happened? This particular company up there did not assail the judgment. Then they, on the other hand, moved an application for arbitration. When they moved an application for arbitration, the Delhi High Court appointed an arbitrator. The Supreme Court judge was the retired judge had been appointed. Arbitration proceedings were filed making claims and all were flagged. NHADCL comes up and says that where is the question of getting all this money? This was termination was held to be legal in the writ court. And now you are now under the problem is res judicata. Now when he comes to know about this thing, he comes up with an application after 835 days and files a writ. We dismiss the writ, it's a difference. there was the delay, not so convincing, but this is what has happened. And this is the fate.
Which is my lordship, my submission is, I'm not pressing by way of a writ. And you will give me liberty to pursue appropriate remedies for all claims, including the claims here. And you may record my statement, your lordship, I will pray for that. Do not want that situation.
There's a big problem with they are facing. Now, because of that, the entire application is gone.
But that is a little bit of a negligence, I would say, because if your writ petition is dismissed for grounds of efficacious remedy and the
No, no,
arbitration-
not on efficacy. On merit,
Merit.
it got this. Although they raised the point of arbitration by the respondent, the petitioner counsel insisted that this is too illegal out there. And as such, you go for this. And the court said that no, it was permissible, rightly done, 226.
So your lordship has condoned the 800
Huh?
days delay? Have you?
No, this is- Because obviously it is a fault of the council. So we say that unless you make allegation against the council, we can't help you. So now, Mr. Tekya, we cannot allow this step.
Well, here what happened, my lord, Lordship has seen the, my lord, particular clause, my lord, it says, my lord, that the development is the, my lord, natural consequences of the termination. Now, no intention to.
Let us see, madam, do you have the judgment where they are making this reference to the
That-
judgment
that
in the
is,
Supreme Court?
Gurkha
This is very
Supreme-
relevant.
Gurkha Supreme.
Yes, yes, I know.
No, this is for 522.
Lordship has
No,
filed-
no, 522, they are making a reference to some NHIDCL circular.
But the judgment, that is Gurkha Supreme.
This Gurkha,
Yes.
Gurkha was given that day, yesterday.
No, I'm
No,
on the
no.
right. Lordship, may I just take a moment of your time?
We go only on this small point.
No, Lordship, because may I?
Yes.
You may then hold against me or not deal with what I'm making my submission. There are two aspects of it. The first aspect, as your lordship says, show cause notice. Gorkha says you're out. Before Gorkha, there's Euroshim, there is Thakur, etc., etc. Gorkha makes it even better, saying that not just any show cause notice, it has to be a show cause notice which has contents which very clearly says why you're blacklisted. So I'm on very strong grounds on that. I did not submit Gorkha, Lordship. I have a copy.
No, madam. The question is, they issued a show.
To which I submitted.
They issued a show. You submitted a report. Thereafter, you work for 1 year. Thereupon, they don't even refer to this show cause and decide. That is why should I go into the history of law? That is for division very
Reason
simple.
being, your lordship, is this. No, lordship, there's one aspect of show cause notice, and I'm relying on Justice Patiwala's technoprint. Technoprint was against the show cause
Then you
notice.
have to go to the
Lordship, hear me, and then,
you have to go to Supreme
no,
Court.
no, lordship, I'm happy with allowing my petition on show cause, but lordship, substantial justice and full justice.
Full justice is not here.
No, lordship may hear. The Supreme,
Then we also decide on the question of termination.
lordship, I'm
once
not
you-
pressing it. I'm not pressing it. I
So-
withdraw that.
And you have bona fide not come out here, so therefore, but you
No,
have
no,
not,
lordship, I have
you
full
are,
lordship, I have
you
no
are
charge of
therefore not
termination.
litigating, you are having various other actions together, a termination, payment,
No, termination.
debarment,
consequence,
all are being
encashment.
taken up together. So it's a misgender of causes of action, we dismiss it, allowing you to find a fresh one.
Lordship will make it very.
Let us
obvious
not
for
go into
As a
the
lawyer,
substantial
it's not
justice.
But as-
Substantial
as-
justice
as a
is for
deputy, it must be
Supreme
always-
Court under 142, not for me. Anyway, I want the judgment which is for NHIDCL legal order circular, which is this. Because this can't be Gurkha, because Gurkha happened in 2014.
Yes.
This circular reference is to 5/9/2023.
But the
This is
judgment
relevant.
is-
That is why they, in spite of having something, they have issued this show cause.
So the judgment is dated 4/8/2014.
No.
Judgment referred to, my lord.
No, kindly see page
On
5.
page 522, paragraph 16.
In one of the
Third-
landmark judgments intimated by NDPS. Oh, okay, so this one.
4/8/2014.
Okay, so they are referring to Gurkha.
Yep.
Now Gurkha, what does it say?
But specific, my lord, the show cause has to be issued. my lord.
Assess. I can-
So in pursuance to that, you have issued circle. I
Yes.
have.
Yes.
You have given too many. I'll give one of these copies to Madam. There are too many
I have
copies.
both,
here.
my lordship. I have both.
No, you haven't. I'll give it to your colleague. So many copies you have given.
Lordship, paragraph 16 of book, if I'm not wrong. Yes, paragraph 16. Starts at paragraph 16. It says, because it's a civil debt, it's stigmatic. And then it cites Euroshin. It cites Raghunath Thakur. Raghunath Thakur, your lordship, was a case where the argument was there is no rules for giving notice. And they say it doesn't matter. It's basic elementary rule of principle of natural justice that you're supposed to give notice. Then material engineering, and then your lordship, paragraph 20. And then it makes it better in paragraph 22 to say not just notice, the contents also must indicate.
No, that I'm not on there. Why should I look into those?
Lordship,
Make
may
it
I,
simple.
may I?
No,
Lordship,
don't
I
allow
feel
me
like
to
taking
go
back.
into this. No, they are yet to adjudicate properly. Let them adjudicate.
No, lordship, I am on.
Page 77. Lordship, you can see page 77.
Okay?
77. Of the petition. Paragraph 17.
Ah,
Paragraph 17.
yes.
Which is not found to be satisfactory. So the representation that has been considered.
No, all understood. You see, a term in the contract, whatever may be, you are after all a state. You cannot, on the basis of a term in the contract, violate the mandate of Article 14, which is the mandate which has been held in Gauhati and all these things. So therefore, issuance of notice is unnecessary, which you have done so. They have replied so. So therefore, the question is, apart from the notice of termination or termination, you have to further go ahead and take a decision as to whether a blacklisting is necessary. Because blacklisting is something which is different from termination. Termination is a contractual termination or a breach of contract where inter se rights of the parties are involved. Blacklisting is been considered by the Supreme Court to be a civil death, meaning thereby you are finishing this company for all times to come. Although you may doing it for 3 years, but then also you are finishing because without 3 years, if no work is being done, they'll lose all the credentials. Not only that, you nowadays have clauses out there for the last 10 years, or 5 years, have you been blacklisted? There's another judgment to the effect that you cannot have it more than 5 years or something to that effect. So these are things, so therefore it has a lot of impact on that. So you have to have a better decision. A termination is for him, but as to whether to finish up the company is another. So there you have to come up with another.
That's what exactly that has been done here. Malad. So far as the termination part is there, so cause notice is different. So far as
You have done that, Mr. Saikia, on termination, whether it is right or not, madam is
Look,
looking it. She's going to arbitration or whatever may be, she doesn't want to press this here. As regards all other things, except on the question of department, department will take a decision properly on the basis of the show cause notice as well as future. Now, taking into account the future course of action, which happened thereafter, you may have to issue a show cause now also.
So that's what
Because you still have the right You see, pursuant to termination, as blacklisting is one of the consequences of termination.
Yes.
It's a
But then-
consequence of a termination.
but then
This
relying
is
on
as per
the
23. It's a consequence of termination. But you need some better reasons. Just because of you are terminated, you cannot do this. There has to be better reasons in view of the Supreme Court case.
Yes, yes, my lord, but that's what exactly my lord done, my lord, the debarment notice, not only mere breach of the agreement, but the various incidents, my lord, that have.
Have you mentioned?
No, check.
Where?
But
See
that-
that, no, that you have not referred to in this notice.
Notice it has been mentioned.
No. In that notice you have referred. Thereupon they have replied,
Yes.
ask for personal hearing.
No.
Hearing given or not, we don't know. Thereupon, you also say in your notice at paragraph 16 that you are going to give a personal hearing. They also say that we will have a person. In the meantime, you allow them to work for such a long time. And thereupon, you say that nothing has been done, so you terminate. Termination is right or wrong, I'm not on that. But you need, for the purpose of debarment, something better. Now, in the meantime, what has happened? Things have changed. What was there in 2025 or March 2025, and the reason for termination after that in 2000, you may have to fill it up, because otherwise you give Ms. Gustami to again come before this.
My lord, what, my lord, because of the.
Though we
but of the-
don't mind madam coming and appearing for this court, but why do you allow this petitioners to come again, taking into account they have such voluminous petitions out there? No, that is for
That is altogether
Supreme Court.
different context.
We have division benches to listen. Yes, you are at liberty to make those comments. That's like, yeah, if you had come up with one reference to that department notice in your order, no, I would have allowed dismiss that because of these conditions.
This, in fact, my lord,
But you have not.
debarment.
You have caused the problem. Otherwise, I would have dismissed the matters. There's not. a
But it is,
single
it is,
word.
it is not a case that, my lord, no so cause notice was issued. It is not a case that.
Understood, but suppose notice, but suppose notice happened when, and thereupon you are not making a reference to the suppose notice a single word also. That's the problem, Mr. Khan. No. I've seen it. I've seen it. That is why I'm saying, if they have mentioned one word of the so-called notices have been issued and this has been done, then nothing has been done, then the thing would have been different. You do one thing, Mr. Saikya, you give them again a so-called notice, and you bar again in another 10 days. I'm sitting out here, let her come with this.
That, what?
No, absolutely no. This is enough. There's no more. For you, therefore, to go to Supreme Court, I'm allowing this petition to you and asking you to go to Supreme Court. Or should we dismiss it so that the division bench also, if I dismiss it also, the division bench will allow your appeal. So then also you can't reach Justice Partiwala. So only way is here, you have no way out. Anyways, I think let me come back in 5 minutes and dictate the order. That is the order which I'm passing. No, no. Well, I reading of these judgments of the division benches.
I'm just what I'm reiterating, although my the department order, or department notice that is, page 81, it has not been referred to the so cause notice.
That is why.
I understand.
My problem is this. Therefore, if there was a reference also, what is Madam asking? Madam is asking so much. Means she's not only asking this, he says, I should pass the judgment and say that you cannot issue a show cause notice also. She's asking that. I'm not on technocrat of this. This is what she's asking.
Case is totally on different premises, one of the fact.
That is too much. That is too much.
But only, yeah, those would definitely positive.
Means
But
you,
only what
if I say, you see, so now what has happened, this so-called notice which has been given, you have, my basic idea is, in February 2025, you have issued a show-cause notice. They reply. In the show-cause notice at paragraph 16, you have categorically mentioned that this is the show-cause notice in view of the judgment in Gorkha. NHI DCL have also issued a circular. So therefore, we are issuing a show-cause and we are going to give you a hearing. They supply a reply on 7/3/2025. Thereupon, you have a video conference with the authority. No, wait. You have an authority engineer video conference. You permit the petitioner to carry out work. But thereupon, on 3/2/2026, you terminate. After termination, you don't make a reference to those show-cause notice or reply or anything. Just as a consequence of the termination, you debar. Now the question is here, you may have a condition. Therefore, paragraph 16 is very relevant. Because this is not a clause only here. It is pan-India, all NHA DCM. Then also you are thinking of issuance of a show-cause notice. When you are issuing such show-cause notice, you have to do it. So irrespective of this, taking into account Article 14, which is more paramount than this, you issue the show-cause note, you have to think that, yes, the termination is a consequence. But for that, you need to fill up further more in your further show-cause notice. You have the right to debar. Because once you terminate, in my opinion, once you terminate, you still have the jurisdiction to debar, because the debarring is a consequence. It's a fallout action. Just for in certain cases in the contract, what happened? There cannot be a risk and cost imposed after the contract is over. There's no quarrel with that proposition. But here, by the virtue of these clauses, it is an extension, or these clauses where you can debar is complementary to the termination clause. So therefore, you retain the jurisdiction for carrying out the termination. But whether the facts necessary for termination is there or not is a question which is to be adjudicated by you. That's I understood. And if you do it within 10 days, again,
But the record would reveal, well, the record, what as I have said, page 77. There already the representation has been considered. And thereafter the termination order has been issued. And since
that, but are you saying, Mr. Zaig, I think the submission would not be proper taking into account. If you're saying that we have considered her blocklisting notice and her reply for the purpose of termination, then wouldn't it be taking into account irrelevant considerations while going for the termination? I think that submission should not be made for your better interest. I think that is the best order. Let me come back in 5 minutes and pass that on. Which one? Let me dictate. Forming the limit to the council assisted by so and so appearing on behalf of the petitioner.
Only one thing I would like to point out, only one thing in the government order that page 81. The lordship will find there that the reference is to the termination order.
No quarrel. There is no quarrel with that.
And that termination order refers to the so-called notice issued for debarment, the reply submitted by them, and thereafter the dissatisfaction of the authority on the reply. So that findings.
Mr. P.J. Saikya, the learned senior counsel, assisted by so and so, appears on behalf of the respondent. The petitioner has approached this court challenging the following. A, the debarment notice dated 3/2/2026. B, the termination notice dated 3/2/2026, whereby the contract agreement dated 22/8/2023 was terminated. In addition to that, the petitioner also sought for a direction upon the respondent to consider the letter dated 5/12/2025 for a mutual foreclosure of the agreement in terms with clause 23.9 of the contract agreement. At the outset, the learned senior counsel appearing on behalf of the petitioner submitted that taking into account that there would be a requirement of adjudication of disputed questions of facts in respect to the termination notice dated 3/2/2026 issued by the respondent, thereby terminating the contract agreement dated 22/8/2023. The petitioner herein would not like to press the said prayer without prejudice to avail remedies available under law. The learned senior counsel also submitted that taking into account that the contract has already been terminated by the termination notice dated 3/2/2026. The question of issuance of a direction for reconsideration of the letter dated 5/12/2025 may not be required to be adjudicated in the instant proceedings. In the backdrop of the above, the question therefore arises in the instant proceedings as to whether the impugned debarment notice dated 3/2/2026 is in accordance with law. Next. For the purpose of deciding the said aspect, this court finds it relevant to take note of certain material facts which have a bearing to the issuance of the debarment notice dated 3/2/2026 as well as the filing of the present petition. The petitioner, the respondent number one, the respondent hearing, along with the petitioner, entered into an agreement on 22/8/2023. In terms of the said agreement, the petitioner was obligated to carry out a contract for widening or improvement of 2 lane with paved soldier from kilometer 16 plus 900 bracket Bogapani to kilometer 27 plus 150 bracket Golaigaon on the existing Dibrugarh to Ledu section with proposed Digboy bypass bracket Greenfield plus Brownfield and Brownfield bracket close bracket open 2-lane dash PS bracket close of NH 315 bracket open old NH dash 38 in Tinsukia district in the state of Assam on EPC mode. Period for completion of the work was how much?
730.
When?
Or it is in the
Period of the completion of the work. As per the said agreement, was 730 days from the appointed date.
From the appointed. From the appointed date, it comes to an end on 6/12/2023.
Taking into account the said stipulation contained in clause 10.3 bracket 1 Roman 1 of the contract agreement. The time for completion of the work was on 6/12/2025. Madam, that is the beginning. That is you go for. Report for the review. That on 5/3/2025, prior to the completion of the contract, a show cause notice was issued to the petitioner. Thereby notifying the petitioner of the decision to debar oblique blacklist the petitioner on account of defaults on the part of the petitioner as per clause 23.1 Roman 1 small Roman 1 bracket C and 23.1 small Roman 1 bracket H of the EPC contract. The managing director oblique the chairman of the petitioner was granted an opportunity to furnish the written reply and personal hearing before the competent authority at the NHIDCL headquarters, first floor and second floor, World Trade Center, New Delhi, within 15 days of service of the said notice. It was made clear that based upon the outcome of the personal hearing, the authority reserved its right and would be at liberty to take further actions for blacklisting oblique debarment of the petitioner. And in such consequences, the petitioner shall not be able to bid any contract of the authority, either singularly or in JB or its related parties for a period of 2 years. The respondent further reserved its right to take further reserved its rights as regards other rights or remedies available under the contract agreement and or applicable law. Paragraph 16 and 17 paragraph 15, 16 and 17 of the said notice, show cause notice being relevant, is reproduced here in under page 522 and 523. The petitioner thereupon submitted a reply on 17/3/2025, wherein the petitioner raised various disputes thereby raised various issues for which the petitioner was not in a position to carry out the work. A perusal of the said affidavit, a said reply, shows that it was the stand of the petitioner that the reciprocative obligations which was cast upon the respondent was not performed by the respondent, which led to the delay in carrying out the work. In addition to that, the petitioner categorically mentioned that blacklisting was an extreme punitive measure with far-reaching consequences for the petitioner's business and reputation. And as such, the recourse to blacklisting cannot be effectuated in an arbitrary, mechanical, or disproportionate manner, but must be predicated upon cogent and incontrovertible evidence of willful default, malafide, or fundamental contractual infractions. It was also a stand taken in the reply by the petitioner that in the show cause notice which was issued, there was no materials placed which would show that the contractual breach, if any, was of contractual breach by the petitioner, if any, was of such an egregious nature as to merit such a drastic consequence of blacklisting. The petitioner also stated in the reply their willingness to appear before the competent authority at HQ NHI DCL on any day and time that the authority may deem expedient. The records, however, reveal that the respondent authorities thereupon, the respondent thereupon did not pursue with the said show cause notice in as much as, and this aspect is apparent from the fact that the petitioner was asked to carry out the various contractual obligations. In that regard, it may not be out of place to mention the communication issued by the authority engineer to the petitioner on 9/8/2025, thereby stipulating the timelines within which certain performance were sought from by the from the petitioner. The records further reveal that almost after 1 year from the date of issuance of the show cause notice, the contract by and between the petitioner and the respondent dated 22/8/2023 was terminated by the termination notice dated 3/2/2026. It may not be out of place to mention that at paragraph number 17 of the said termination notice, there's a reference to the show cause notice which was issued to the petitioner and the reply so submitted by the petitioner. Pursuant thereto, on the same day, the impugned notice for debarment was issued. The respondents in the said debarment notice refer to clause 23.1 Roman 5 of the contract agreement and stated that on account of the termination notice issued on the same day, that is on 3/2/2026, as a natural consequence to such termination, the petitioner was debarred for a period of 2 years, and the petitioner shall not be able to bid any contract of the authority, either singularly or in any JV or its related parties. It is under such circumstances the petitioner has approached this court, seeking the various reliefs as aforementioned. The record reveals that this court, by an order dated 18/2/2026, issued notice and further, as an interim measure, state the impugned debarment notice dated 3/2/2026. The said notice, the said interim order had been thereupon continued from time to time. It is further relevant to take note of that the respondent had filed an affidavit in opposition, placing on record various materials, various enclosures, thereby justifying the debarment notice as well as the termination notice, both dated 3/2/2026. In the backdrop of the above, this court have heard the learned counsels appearing on behalf of the parties. Mr. Goswami, the learned senior counsel appearing on behalf of the petitioner, submitted that the impugned Shoko's notice and that the impugned submitted as already recorded herein above, that the petitioner would not insist on the relief pertaining to the challenge to the termination order dated 3/2/2026, as well as the any other consequential relief to which the petitioner is entitled to. The learned counsel, however, submitted that the said submission is made taking into account that for the purpose of determination of such the impugned termination order, this court may have to enter into various factual adjudications which may not be permitted within the contours of Article 2 of the jurisdiction of this court under Article 226 of the Constitution. Taking into account, she, however, submits that the petitioner, that the withdrawal of the relief pertaining to the challenge to the termination notice in the instant proceeding should not preclude or prejudice the petitioner to approach the appropriate forum. The learned counsel further submitted, the learned senior counsel further submitted that the impugned debarment notice is contrary to the law laid down by the Supreme Court in various judgments. First, it is the submission of the learned senior counsel for the petitioner that the said show cause notice of debarment was not preceded by any show cause notice. The learned senior counsel submits that though there was a show cause notice which was issued on 5/3/2025, the petitioner thereupon submitted a reply on 17/3/2025 and sought for a personal hearing. Thereupon, the petitioner was allowed to carry out the work as would be apparent from the materials on record. There, it is also seen from the materials on record that all of a sudden, on account of the termination notice dated 3/2/2026, as a consequence thereto, the notice of debarment was issued. The learned counsel, senior counsel, referred to the judgment of the Supreme Court in the case of Gauhati Security Services versus Government NCT of Delhi and others, reported in 2014, 9 SCC 105. And submitted that the facts in the instant case are similar, inasmuch as the clause on which the petitioner have been debarred and upon which the respondent have issued the debarment notice a similar provision was before the Supreme Court, as would be apparent from paragraph number 24 of the judgment in the case of Gauhati Security Limited Security Services. The senior counsel submitted that in spite of that, the Supreme Court categorically observed that blacklisting cannot be carried out in spite of such a clause. Inasmuch as mere termination of a contract would not be sufficient for the purpose of blacklisting of the contractor, the learned senior counsel submitted there is something more required, to the effect that there has to be an egregious contractual infractions in that regard. The learned counsel, senior counsel, referred to paragraph number 26, 27, 28, and 29 of the said judgment. The learned senior counsel for the petitioner further submitted that even the respondent authority duly acknowledges the said aspect as would be apparent from paragraph number 16 of the show cause notice dated 5/3/2025, wherein they specifically refer to the judgment in the case of Broadcast Security Services Supra and mention that there is a requirement of a show cause notice and a personal hearing. The learned senior counsel further referring to the judgment of the Supreme Court in the case of Blue Image Advertising Private Limited and another versus Kolkata Municipal Corporation and others, reported in 2024, 15 SCC 264, submitted that the Supreme Court had been categorical in observing that in the case of ordinary breach of contract and breach of contract, and when explanations are offered by the person concerned raises bona fide dispute, blacklisting of the debarment as a penalty ought not to be resorted to. The learned senior counsel, referring to paragraph number 25 and 26 of the said judgment, submitted that in the instant case, the petitioner have raised in the reply submitted on 17/3/2025 about non-performance of reciprocal obligations by the respondent, and further have also mentioned and as such, there was a bona fide dispute. Under such circumstances, merely on the ground that a contract was terminated without there being an adjudication as to whether there was a bona fide dispute or not, the respondent authorities straightaway could not have issued the debarment notice impugned in the instant proceedings. The learned senior counsel further referred to the judgment of a recent judgment of the Supreme Court in the case of Technoprints versus Chhattisgarh Textbook Corporation and another, reported in 2025, SCC Online SC 343. And in that regard, submitted that a similar clause like clause 24, 23.1 Roman 5 of the contract agreement was present in the state proceedings, that is clause 16.9, and therefore submitted that in the said case, in spite of the presence of a similar clause like clause 16.9 and a show cause notice having been issued, the Supreme Court interfered on the ground that there existed bona fide disputes for which the recourse to blacklisting was not permissible. The learned senior counsel submitted that even the show cause notice was interfered with by the Supreme Court in the same judgment. Anything more? By contra, Mr. PJ Saikia submitted that it is not the case submitted. The petitioner was issued a show cause notice on 5/3/2025. The petitioner submitted a reply on 17/3/2025. Though the petitioner was allowed to carry out the work, but that was done on account of public interest.
So as per the clauses of the
Public interest in as much as termination of the contract would entail issuance of another notice in another tender process, and thereby there would be delay in the construction of the roads in question. The senior counsel further submitted that in spite of opportunity being granted thereafter also, the petitioner did not carry out the work. And in that regard, have referred to the various notices which have been issued and closed with the affidavit in opposition. Situated thus, the respondent authorities were compelled to issue the termination notice. The learned senior counsel further referred to paragraph number 17 of the said termination notice and submitted that in the said notice there is a reference to the show cause notice which was issued to the petitioner on 5/3/2025 and the reply which was submitted on 17/3/2025 by the petitioner. These aspects were duly taken note of, and thereupon, under circumstance, therefore, the respondents, under compelling circumstances to maintain and improve the infrastructure, had to terminate the petitioner. The senior counsel further submitted that in the impugned notice for debarment, there is a reference to the speaking order, the termination order, dated 3/2/2026, and the said termination notice refers to the show cause notices as well as the reply. And therefore, it should be deemed that the said term notice for debarment was preceded by the show cause notice as well as the reply which were duly considered. Analysis and determination. This would have given an anxious consideration to the respective submissions. The question which is involved in the instant proceeding is as to whether the action on the part of the respondent to issue the notice in the impugned debarment notice is in violation to Article 14 of the Constitution, 14 and Article 21 of the Constitution. It may not be out of place to mention that Article 14 of the Constitution negates any arbitrariness, unreasonability, unreasonableness, irrationality, and illegality. Whereas Article 21 of the Constitution categorically mentions, whereas the principles of natural justice is considered to be a facet of Article 21 of the Constitution. In the instant case, it would be seen that on 5/3/2025, a show cause notice was issued to the petitioner making various allegations. In the same show cause notice, and more particularly at paragraph number 16, there's a reference to the judgment of the Supreme Court in the case of Gauhati Security Services. And it is under such circumstances, the show cause notice was issued to the petitioner, and thereby also affording a personal hearing. The petitioner thereupon submitted a reply on 17/3/2025, wherein not only the petitioner have raised various issues pertaining to non-performance of the reciprocal obligations, the petitioner also stated in clear and categorical terms that the facts in the present case did not the facts in this in the facts the allegations made in the show cause notice were not of such substance which would call for which would require steps for blacklisting. The petitioner also submitted that the petitioner would be participating in the personal hearing at the place as mentioned in the show cause notice dated 5/3/2025, as and when the respondent authorities duly informed the petitioner. Admittedly, there was no personal hearing. And on the other hand, the petitioner was allowed to carry out the various contractual obligations. Be that as it may, the respondent authorities thereupon issued the termination notice dated 3/2/2026. It surprises this court to take note of the debarment notice dated, which is impugned in the instant proceedings. Though, in as much as, though the learned senior counsel appearing on behalf of the respondent had categorically mentioned that there was a show cause notice and there was a reply which were duly considered in the notice for termination. But in the opinion of this court, the notice for debarment should have contained the reference to the show cause notice as well as the reply thereagainst. This court also finds it relevant to observe that it is a facet of Article 21, a facet of the principles of natural justice as has been held in the case of Gauhati Securities Limited Services, Supra, that not only a show cause notice would suffice, there would be a further requirement of a personal hearing. In the show cause reply submitted by the petitioner on 17/3/2015, it was categorically mentioned that the petitioner be informed as to the date on which the hearing would be taken up for the purpose of hearing would be taken up in respect to the issue pertaining to debarment/blacklisting. Without any such hearing, the respondent authorities resorted to clause 23 1 bracket Roman 5 of the contract agreement and issued the debarment notice. This court also finds it relevant to take note of the judgment of broadcast security services, and more particularly clause 24, paragraph 24. And 25, which is reproduced here in under. A perusal of the above paragraphs would show that a parameter provision like clause 23.1 Roman 5 of the contract agreement of the present contract agreement was also there as clause 27 A, which was the subject matter of consideration before the Supreme Court. The Supreme Court, in spite of the presence of such a clause, categorically observed that there was a necessity of following the principles of natural justice. In this regard, this court finds it further pertinent to take note of paragraph number 26 and 27. And 28 of the said judgment, which are reproduced herein under. The above analysis would therefore show the above quoted paragraphs of the judgment in the Supreme Court would show the mere existence of a clause similar to clause 23.1 Roman 5 of the contract of the present contract agreement would not suffice to take steps for blacklisting public debarment without a further action being taken to ascertain the requirement for blacklisting. In this regard, this court also finds it relevant to take note of the judgment of the Supreme Court in the claims of Blue Dreamers Advertising Private Limited, Supra, in as much as this judgment portrays as to what are the requirements to be looked into. And this judgment specifically in the same judgment, the Supreme Court had categorically opined as to when recourse to blacklisting should be resorted to. Paragraph number 24, 25, and 26 being relevant are reproduced herein under. From the upper paragraphs, it will show that on account of ordinary breach of contract or where there is a bona fide dispute, it is not permissible to go for a blacklisting. In other words, for the purpose of going ahead with the blacklisting, something more is required. There's something more which is required for the purpose of taking up steps for blacklisting. Can be decided by the respondent only upon issuance of notice to the petitioner. Inasmuch as it is the specific case of the petitioner in the reply, dated 17/3/2025, that the petitioner therein was not solely responsible for the delay. This court also duly takes note of the judgment of the Supreme Court in the case of Technoprints, wherein at paragraph number 27, 28, and 29, the Supreme Court, 29 and 30, the Supreme Court deals with as to when wherein the Supreme Court 29 and 30, at paragraph 29 and 30 deals with as to when there could be a case for issuance of a show cause notice. In the instant case, the said paragraphs being relevant are reproduced here in under. In the instant case, it is the opinion of this court that the show cause notice dated 5/3/2025 would not have been the basis for issuance of the notice, department notice. Further to that, and under such circumstances, the said show cause notice dated 5/3/2025 would not have been regarded as a notice for the purpose of the debarment notice dated 5/3/2026. As therefore, under such circumstances, as there was no show cause notice, this court would not like to further deal with as to what type of show cause notice should have been issued or not. More particularly taking into account that at paragraph number 29 and 30 of the judgment of in Technoprints, as Supra, as quoted here in above, the Supreme Court have already dealt with the same aspect. Considering the above, this court therefore disposes of the instant petition with the following observations and directions. The impugned notice of debarment dated 3/2/2026 is set aside and quashed. This court further directs, this court observes that in terms of the conditions of the contract, the respondents have the power to proceed with debarment of blacklisting pursuant to termination of the contract. However, debarment and proceed. However, for going ahead, however, such debarment oblique blacklisting cannot be carried out mechanically. It should be preceded by a show cause notice and an opportunity of hearing to be hearing to be granted. Number 3. Under such circumstances, despite the notice of debarment dated 3/2/2026 is being set aside by this court, liberty is granted to the respondents to initiate proceedings for debarment by following the law laid down. Next, this court further observes that while initiating a fresh process for debarment, the respondent authority shall duly take note of the judgment of the Supreme Court in the case of Blue Dreamage Advertising Private Limited, Supra, as well as paragraph number 29 and 30 in the case of Technoprints, Supra. Next, this court further observes that the withdrawal of the prayer of termination dated 3/2/2026, as well as all other consequential actions in the instant proceedings, except the debarment notice which have been considered by this court, shall not prejudice or preclude the petition to avail remedy before the appropriate time. there shall be no order as to cost in term of dispensary. Also, what is this? Oh, there. There's a selling council. Like you are the selling council Muslim Ali, he's the selling council for him. And it is very strange that he's sitting with Mr. P. Gokul. They are always in dialogue. We're chilling. Where's the technical evaluation? Improvement and upgradation of so yes. What is your name? Oh, you are also qualified. Then? Then? Why? Where's the minutes? Please. So that's why your file is on my file is only. See, so big. Yeah. Yes. This is revenue from operation. Now, this is statement of profit and loss. One has to see not from that. Where is the balance sheet statement of profit and loss for ending 31/3? 31/3, 2023. This is statement of, yeah, this is an audit. 44 AB is audit. This is particular for audit. Balance sheet is on the so cash in. This is the document why he had to submit it. No, wait, if this is the document he has submitted. Yes, Mr. Come there. We don't hear you at the moment.
Submitted, but it was a typographical error, my lord, on the part of the CA, my lord. In fact, my lord, the 5 years statement was there, my lord, and one recently downloaded, my lord, that's also shown, my lord, the figures, my lord. Kindly come to, my lord, 5 years statement, you must find, my lord, is put 50, put 53, my lord.
22 crore.
Yes. This is the turnover of last 5 years, my lord. And it was effectively there, it is there, my lord. For the year 2022-23, it was 22 crore, 85 lakhs, 90,831. But
No. My question is, see, you have submitted, they have accepted.
yes, my lord.
Now the question is whether this particular document, it is 485, it is shown as 22 crores 85. This is from sales.
My lord, in fact, my lord, the election was also sought for by the issues chief engineer, Mr. Kograzer, my lord. Yesterday he had received, my lord, but he had also sent the clarification, my lord. And the figures, my lord, which he had downloaded from the, my lord, Institute of Chartered Accountants of India, my lord, same, my lord, same figure. That 88 to 8 crore something, my lord, that is not there. That was clerical error, my lord.
No, that has no relevance. You see, this statement of profit for earlier year is not relevant. We had made the other one. If you have put it, how much? 21, 22. Yes, this is. Now you for the statement, therefore, where is your statement of profit and loss for 2000 year ending 31/3/2024?
Yeah, my lord. Check whether the equal lordship comes to page 45 method. The close that 4.5a method. Then 4.5a method. To qualify for award, the context is either in this name should have in the last 5 years, that is 2021, 2020, 122, 22, 23, 23, 24, 24, 25. Minimum annual financial turnover. Kindly come to criteria method. Here, method. Achieve a minimum annual financial turnover in all cases. Or in all classes of civil engineering construction work only of 50% of the DNAT value in any 1 year. And there also, my lord, in this column, my lord, in close, my lord, I have also a
What
class.
is the GST doing here? What GST? This is the GST on 9C, this is the final return.
That we can.
So if it is 8 crores, then he can't get it.
Yes, no. It needs, my lord, 11.6 crore.
Huh?
11.6 crore.
11.7. So if
In
you-
any 1 year.
Huh?
In any 1 year, the last 5 years, sir.
Any 1 year.
Yes, yes, that is especially there.
So he has one.
I have already, my lord. Even in that.
Only on that point. There's no more point. Yes, yes, others may go, others may go.
My lord,
Yes, madam. 4.9. Point seven.
Miller note.
No, even though the bidders meet the above qualification, subject to be disqualified if they have made misleading or false presentation.
Miller.
No, whether that is required to be submitted or not. But here it says reports on the financial standing of the bidder such as profit and loss statement and auditors report for the last 5 years. So you have given only 3. So only case is 8. There is no other group.
Yeah, my lord, in this, their case also I have something. In their technical bit also I have something to say, my lord.
Huh?
Yeah.
T and 4B, not 4. 4B. B has been properly studied. No, no. B has 3 and 4B. Properly signed. It is accompanied by a each substantially responsible. No, this again boils down to 4.8, 4.38. So the only issue is 4.38.
Yeah, my lord.
What manipulation? No, if it is A, is out. Or is not out.
Not out, my lord. Other, we are only 1 year, my lord.
Other than. So therefore, whether the document is disqualify you, that's the only question. There is no manipulation by him. No, he has not done it by hand. This has been filed. These are public documents. This is already available. You can go to get it. No, you see, thing is, no, GSTR has no business also. GSTR has nothing. Because GSTR is sales. No, GSTR is sales. GSTR is the final return. What?
Regarding the turnover as that submitted one copy, my lord, that was downloaded today itself, my lord.
Which one?
That,
What is it?
my lord, the turnover, my lord, here was turnover.
It is shown as that. No, this GSTR you are referring to is wrong. It is this GSTR is the final return filed under section 44. This is pertaining to goods and service tax. Goods and service tax, supply of goods and service tax. That is different from their sale. Understood. So before it is 458, 460. No, 461. 461 is 8 crores, 85 lakhs, 90,000.
That was shown to be, my lord.
That should have been 982 crores.
Yes, sir. That is 22 crore.
So this is for the year 2023-24.
8 crore, 22, 23.
You ask your fellow whether you have filed a DSM correction rectification.
Right.
You've done it.
Right. And moreover, my lord, in that technical bit also, my lord, that is a joint venture, my lord. Each and every partner, my lord, joint venture company, my lord. Please kindly come to page again, 45.
Ah,
45 page, my lord.
45.
Yes, sir. That was my lord, 4.5 page, my lord. The right side, my lord, criteria, my lord. Qualifying requirement, my lord. Active right, my lord, each partner, my lord, must meet 30% of the requirement, my lord. Turnover, my lord. My lord, here in this case, my lord, I have gone through their record, my lord. In respect of Doyle, my lord, Doyle Das, who is a, my lord, associate, my lord, Jogesh Das, my lord. In respect of Doyle Das, my lord, no turnover is there, no record. But it is there, my lord. He have to contribute 30%, my lord, at least.
Okay, madam, what is the contract for?
Alia process, your lordship. And this repetition constitutes disputed petition of facts within the lordship will entertain matter.
What is the dispute?
All the speakers and facts that are sitting in the writ court, the lordship may exercise matter. Then they go to the civil court. Lordship and another aspect of the matter in the lordship. He happens to be the power of attorney holder.
Who?
This present petitioner. Lordship, but under the Supreme Court judgment is there to that effect. He has to cite the reasons, my lord, on why he was given the power of attorney in the writ petition. If he files a writ petition, Lordship, everything details has to be given in the writ petition, my lord. Nothing has been given. Lordship, the power of attorney by which the donor authorized attorney must be brought under record and must be filed together with the petition. That is there. It's a part of the tender document.
He
The
has not
affidavit
enclosed-
which is
mean to say he has not enclosed the power.
He has enclosed, it's a part of, he has enclosed, it's the part of the tender document, separately as not filed. Lordship, the affidavit which is executed by the holder of a power of attorney must contain a statement that the donor is alive and specify the reasons for the inability of the donor to remain present before the court to swear the affidavit. And the donor must be confined.
In these aspects,
Lordship may not go.
that is for Supreme Court.
Lordship,
Let me dismiss his petition.
my lord.
So Supreme Court. My question, therefore, we do one thing. What is the present position?
Present position, Lordship, the honorable court order, we process the matter, but no final order.
What is it?
Last Friday order, Lordship first one.
Yeah.
Notice has not been issued. The pleas today is different, Your Lordship. On the last occasion, they say they had made the plea as a discrepancy as regard this one, facts and figure. Now they have come up with another submission that some papers were not submitted. And that another plea was that while opening the bid, they were not informed.
Anyway, we do one thing. We don't pass an order like this without issuing. Issue notice short then, before the issue. You file your, and whenever you file your, in same order, we continue till the issue notice making. Yes, Mr. Gugor, you have got some emanations for other cases against you. Otherwise. So I was thinking when you are appearing out there, whether you are there DSP, preparing for a DSP, no.
Yes, for the PWT.
Yesterday I passed the judgment on the DSP. You have to use data. So this will help you. You should notice making it returnable on 23rd of June 2026. Mr. B. Gogoi, the learned additional advocate general, as well as the standing counsel of the PWD department, accepts notice on behalf of number 1 and 2. B. Bhuya, assisted by Soen, learned senior counsel, assisted by Soen, so appears on behalf of the respondent number 3 to 5. Mr. S. Hawk, the learning counsel, appears on behalf of the respondent number 4. All the respondents being represented, extra copies of the petition be furnished to them by tomorrow. The petitioner herein who had participated in pursuant to a notice inviting tender dated 16/2/2026 issued by the respondent number 3 for construction of road and bridges under the Assam Mala 3.0 for the year 2025-26 in Tamilpur district. Along with, in pursuance to the technical evaluations being carried out, it was found that the petitioner as well as the respondent number 4 are the technically eligible bidders. This technical evaluation so carried out by the respondent have been put to challenged by filing the instant writ petition on the ground that the respondent number 4 had bid would not have been taken into consideration, taking into account that the petitioner was not eligible in view of non-compliance to clause 4.3H 4.3H of section 1 of the instruction to the bidders. The learned senior counsel submitted that in terms with the said clause, the petitioner is required, the respondent number 4 was required to submit the reports on the financial standing such as profit and loss statement and auditor's report for the last 5 years. In the specific case of the petitioner, that the respondent number 4 had not submitted for 5 years, rather the respondent number 4 had submitted only for 4 years.
3 years.
For 3 years. In addition to that, the learned senior counsel appearing on Mr. Dida, the learned senior counsel appearing on behalf of the petitioner had further submitted that the documents which have been submitted by the respondent number 4 appears to be manipulated, taking into account that on one hand, the certificate which have been submitted of the auditor of the chartered accountant, the chartered account, shows that for the year 2022-23, the total turnover was for the respondent number 4 was 22 and odd crores, whereas from the profit and loss account of the respondent number 4 as on 31/3/2023, it has been shown at around 8.5 crores. He therefore submitted that on that account also the respondent authorities ought to have rejected the bid of the respondent number 4. It is the opinion of this court that these very aspects can be seen from the records of the proceedings, record of the tender evaluation being produced before this court. And further, granting an opportunity to the respondent number 4 to bring on record its stand. The affidavit of the respondent number 4 be filed on or before 19th of June 2026. Liberty given to the petitioner to file reply on or before 22nd of June 2026. The respondent authorities, more particularly the respondent number 3, is directed to produce the records of the tender committee. The interim order passed on such and such date, 5/6/2026, shall stand extended to the next. No. Okay, all interim orders will be extended. Anybody wants a date?
Regarding cancellation of tender, in fact, today item number 3 is very covered out. We have got a several. He is the advance bidder and it was cancelled without giving any alloy. Already covered.
It's a Monday matter.
Oh.
This too, there are some matters which are considered for hearing. On Tuesdays and Thursdays. Otherwise, these small matters I consider it for Monday. The Monday matter. Okay, we have it on Friday, next Monday. Next Monday.
May I kindly
Yes,
mention?
Mr. B.D. Deka, what are you doing in the bench 4 matter?
There's a commercial suit.
Oh, that matter, what has happened? Have you submitted the
We've
draft?
submitted the proposed issues, my lord. The only confusion we had, if your lordship is trying it as a commercial suit, perhaps you have to meet the timelines for admission and denial and also for inspection. So therefore, we were a little under confusion whether we should follow that procedure. If that be so, we'll have to adhere to the timelines.
What is the timeline?
Well, 30 days, within 30 days from the filing of the WS come against the counterclaim, we need to finish out the inspection part. And thereafter, within 15 days, we have to file the admission and denial.
We have it on Thursday. Say 2, then we take it up.
Lordship, may I allow to mention item number 24, Lordship? I'm sorry, I'm on a VC, Lordship. Item number 24, if this could be a fixed date of 22nd of July, Lordship.
24.
24, item number 24, Lordship. I'm for the respondent side. I have apprised the petitioner side for 22nd of July, if it's suitable to Lordship's diary.
Okay. You are taking.
Highly aware, Lordship, highly aware.